We rise, justices of the Appellate Division, Supreme Court, First Department. Please be seated. All persons having business with the Appellate Division. Draw near to your attendance and shall be heard. Please be seated.
Okay, good morning, everybody, and welcome to the Appellate Division First Department. Sorry we didn't have better weather for you, but we are certainly glad that you're all here. We have scheduled at the moment 8 hours of oral argument. So since I don't think any of us are hoping that we're still hearing arguments at 5 or 6 tonight, I would ask you to please ask for just the time that you need. Remember that we've had the briefs and the records and are very familiar with with your cases. If we have questions, we will continue asking them. You know, you are supposed to stop when the red light goes on. You don't have to stop in the middle of a sentence. And when the white light goes on, you have 2 minutes left, for those of you who've never been here before. So I'm going to call the calendar, and let's see what we can do. The first case, and just so you don't have get crazy, I do know that, and I do remember that I made a commitment to the Tully construction case. That's going to be argued first. So one of the attorneys has a conflict and has to get to the Appellate Division Second Department, so we try to work with each other. But I'm going to call the cases in the order that they're written on the calendar. Number one, People versus Carl Gainey. And where's the respondent? 6, 2, and 6. Thank you. Lyman versus J.P. Morgan Chase.
For the appellant, Your Honor, I'm requesting 10 and 5.
Okay, 5, 2, and 5. You're not getting the idea. You're not supposed to be requesting the maximum here. We'll be here all night. All right, have a seat. The next case is in the matter of Celesta S. That case is submitted. Bank of America versus ASD Gem Realty. Wait, I want to hear, appellant is who I want to hear from first. Is the appellant here? What? Both parties checked in? Did we lose somebody? Sweet should be the appellant and Aronson should be the respondent, I think. Are you? Yes? Okay, 5 and 2 and 4, thank you. GFE Jerome Avenue versus Steph Lee Associates. Okay, and cross appellant? You also have an appeal, right? You're a cross appellant. Do you want rebuttal time too? Huh? Okay, so 5 and 2 and 4 and 2. Thank you. Gateway International versus Richmond Capital. Nobody? Oh, okay, that case is submitted. Ingrati versus Avalon Bay. Thank you very much. You got that. 5, 2, and 5. Medina versus 676 Hunts Point.
676 Hunt Point, appellant, request 6 minutes and 2 for rebuttal.
And where's GMH? You're the other appellant, right? 5 and 3. All right. I'll give you 6 and 2. I'll give you 5 and 2. And then there's 2 respondents here, plaintiff and the co-defendant. Okay, and plaintiff? Plaintiff? Not here? Okay, thank you. You may be seated. Anderson versus AHS at Home Solutions. Submitted. New Hampshire Insurance versus MF Global. Yeah, we're very familiar. Are you the only one arguing on behalf of the appellants?
Yes, I am, Your Honor, and we request 10 briefings.
and who's MF Global? Okay, 8 and 2, 8 and 2. If we have questions, I assure you we'll continue. Thank you both very much. M Children? 6 and 2. Is there anyone else here on the case? Would you still like to argue? Okay, we'll give you 3 minutes, okay? If we have any questions. Thank you very much. Tully Construction versus New York City Department of Design.
Good morning. For the appellant, 8 and 2.
And respondent?
IPC 5, please.
Okay, 7 and 2 and 5 and 4. Okay. Thank you all. Wu versus 34 17th Street. Okay, and respondent? Okay, thank you. People versus Orozco? Okay, 6, 2, and 4, thank you. Hess versus EDR Assets? Okay, 6 and 2 and 3, thank you. People versus McDowell? And respondent? Okay, 5 and 1 and 5, thank you. London versus London.
Good morning, Your Honor. For the appellant, 6 and 3.
Okay, 5 and 2 and 6. Okay, thank you. Semper versus Karamitsos. 5 and, okay, and respondent? Okay, thank you very much. 5 and 2 and 4. People versus Fofana? No. Okay, that case is submitted. And Schindler versus Selco Partnership is submitted. As I said, we are going to start with Tully Construction versus New York City Department of Design. Tully Construction? Didn't you guys want to go first? The other respondent can sit in the back seat. Mr. Malonis, do you want to stay there? Or you can sit in the back, whatever. Okay. Council, if you'll come to the center podium because the mic is there. Everybody, please remember to keep your masks on, but with the mics, it works pretty well.
Thank you so much.
Good morning.
I apologize.
Not a problem.
Jeffrey Cohen for the appellant. If it pleases the court, appellant Tully. It is quite the day to be discussing a resiliency wall along the east side, unfortunately. We have taken the position and maintain the position that the sworn-to bid form that IPC submitted on February 8, 2021 identified MLJ, Basilico, and CAC, the combined revenues of which totaled only $855,773, less than the $1 million special experience requirement. That special material requirement is a prerequisite.
Counsel, why wasn't DDC allowed to determine that that was simply a ministerial error?
Because it wasn't a material error.
Ministerial.
Yes, I understand that they do have discretion And we don't disagree that the city has discretion, but we believe that it was illegal, that it doesn't have the discretion to make something illegal legal. It has the discretion to make certain determinations. So that is our position.
But there was a preliminary period during which people who would be interested in bidding were allowed to ask questions. And one of the questions that was asked was, would it be possible for a joint venture to make this application? And the answer was yes. So when the joint venture put together their ultimate bid, there were several different groups together, and it did, together, their prior work was over, I think, was it $1 billion that they had to have to show that they were eligible to make a bid?
That is correct.
So if they said it's okay that you are a joint venture, how can we, what's the problem here? I mean, I know it might be frustrating because you're one company that has that, and there are a bunch of companies, but still they said that was permissible.
Nevertheless, the joint venture aspect, it should be noted that the EIN first came into effect the day after February 9th. What we're concerned about is the integrity of bids. What we are concerned about, almost as importantly as the flood wall, almost as importantly as the ravages of climate change, is the integrity of the bids. Sealed bids must follow the sealed bid law, 103 of the municipal law. And in this case, we maintain that by naming MLJ intentionally, it was only after, and together, I should say, together with the sealed bid, thank you. Of course, it causes fog, so I apologize, as we all are confronting this dilemma. By naming MLJ intentionally and not naming anyone else, the joint venture may not have even been in effect at the time. What we have is a form.
Well, they apparently were three separate companies, MLJ, Welkin Mechanical, and J-Track LLC, that were all owned by the same individual, correct?
And we find that out months later. This is after the bid. The bid is in February. We find out months later about Welkin. We find out months later about J-Track. But we don't know on the day of the sealed bid about those companies. That's what we are concerned about. It is the integrity of the sealed bid that we are most concerned about, and MLJ was intentionally filed as one of three partners, tri-venture. MLJ, not Iovino.
Counsel, you're not, I'm sorry to interrupt you, but you're not now contending that a joint venture cannot bid. It's just that MLJ was incorrectly named, and that meant that they were below the $1 billion threshold.
That is correct.
Because in fact, in a previous bid iteration, didn't Tully participate?
Wait, let him finish.
I'm sorry, Counsel.
No,
On a previous bid iteration, didn't Tully participate in a joint venture?
Yes, on a previous bid,
Right.
that did happen, and that really is not, that isn't the issue here. This is one name, this is MLJ, and one of the arguments we will hear is that the I is Iovino in IPC, which is of course self-serving. It doesn't mean anything. Iovino being IPC it could be IRS, it could be anything. It is irrelevant. It was MLJ. MLJ is IPC, and they did not meet the requirement. They did not meet the special experience requirement. And by doing so, they fail as a proper bidder. And therefore, Tully is the only legal bidder on this project and should be granted the bid. It could be granted by this court, and we've presented case law on it, or we would most respectfully respectfully request that this honorable court send the case back to DDC to rebid. It's my understanding that currently there are other cases involving this project that I'm sure you're all aware, and construction has not begun as yet, and we are of the opinion that it should be forwarded back to the DDC to be rebid.
Okay, well, you have 3 minutes, 3 seconds, so I'm going to say very nice to see you, and we'll give you 2 minutes on rebuttal, okay?
Thank you much.
Thank you very much.
Should I be seated here?
Please.
Thank you.
The city going to argue next? Okay, you have 5 minutes, and your co-respondent will have 4 minutes. Thank you.
Good morning. May it please the court, Kate Fletcher for the city respondents. Initially, I would just like to thank the court for accommodating my scheduling difficulties and graciously moving us to the beginning of the calendar.
No problem.
This court should affirm. The simple fact is the bid form complaints that Tully raises are not preserved and are not properly before this court. They were not submitted at the administrative level and cannot now be raised for judicial review. And in any event, even if one were to proceed to the merits, they are baseless. IPC submitted its bid form, listing IPC as the bidder, as well as its special experience requirements statement on February 8th. In the special experience requirements statement—
Where was the document that listed MLJ and not IPC? Was that before the final bid, or was that what point was that?
That was the bid form, Your Honor. And that was submitted on February 8th.
Right.
And along with that form was the special experience requirements statement. And that listed Iovino affiliates, as well as Basilico and CAC, as the members of IPC. That was February 8th. Then, on February 16th, additional documentation was submitted for the 2018 and 2019 financials of the components of Iovino affiliates. So that includes MLJ, JTRAC, and Welkin. It is not the case that it was months later. It is not the case that IPC changed its composition. It was always IPC, it was always Iovino, Basilico, and CAC. And the UDC exercised its discretion rationally in allowing a joint venture entity to combine its revenues. Joint venture entities are formed for the specific purpose in construction industry of bidding on a particular project. In this case, these companies came together, and it was entirely rational, and it comported with industry practice for DDC to look at their revenues combined. And accordingly, this court should affirm.
So, counsel, when you say that this case is not here before us appropriately, what portion of the process are you referring to? Is it the part where there's an opportunity for bidders to make requests for interpretation or clarification, or was it something else?
Yes, Your Honor. Specifically, Tully's complaints about the bid form and about listing MLJ on the bid form were not ever placed before DDC in the form of a bid protest. So they had previously submitted a bid protest saying that you can't combine revenues. And then they submitted an additional letter to the Corporation Council raising their complaints about the bid form. But under the clear rules of the Procurement Policy Board, that is an improper way to submit a bid protest. And there is no room for that to be submitted through Corporation Council. It's very clear that actual delivery to the commissioner of DDC is how you file a bid protest. And under these circumstances, the complaints—
Counsel, notwithstanding that technicality, which is important, your adversary raises this issue of the integrity of the bidding process. If we were not to at least consider the arguments that they're raising, with IPC being one of 3, maybe one of 6 joint ventures all putting their money together, how do we protect the process if we don't consider that?
Well, here DDC exercised its discretion, which it's vested with, in deciding that it was that there was no problem with the bid submitted by IPC. There is no question that IPC has been consistent in what it has reported to DDC, and that IPC has been consistent in showing that it meets all of the special experience requirements. So while Tully wants to project that there are concerns about the integrity, in fact, the process and DDC's consideration of IPC's bid as a joint venture facilitates competition because it allows newly formed joint ventures to bid on these kinds of construction projects, whereas
You maintain that DDC complied with the bid booklet, which said that failure to comply with the special experience requirements would result in rejection of a bid as non-compliant?
DDC did comply because IPC complied with that special experience requirement. They met the $1 billion revenue requirement, and they did so as a joint venture.
Okay, thank you very much.
Thank you, Your Honor. Thank you, the court.
I think you'll have enough time to get to the second department. Okay.
I still haven't learned how to keep my glasses unfogged, so
Yeah.
I'm here when I need
The
them.
world.
But anyway,
Morning.
I'd like to begin just by going over the ground rules, which I know the court knows, but I'll quote as part of a decision from the Court of Appeals. It's Flack. Judge Alexandra wrote it, and it talks about it is settled that in a proceeding seeking judicial review of administrative action, the court may not substitute its judgment for that of the agency responsible for making the determination, but must ascertain only whether there is a rational basis for the decision or whether it is arbitrary and capricious. Moreover, whereas here the judgment of the agency involves factual evaluations in the area of the agency's expertise and is supported by the record, such judgment must be accorded great weight and judicial deference. And there's an appellate division decision, unanimous, Peter Thomas and JP, then, with the same almost identical language. So the city asked for a lot of information. They were given a ton of information. This process went on even after the bid, when there were meetings with staff. They went over the figures. They went over whatever was necessary when the experts negotiated this. So this is well, how to put it to you, papered, well discussed, well planned out.
Counsel, the plaintiff says the integrity of the process is at stake. And essentially they're saying there was an initial bid and then Tully switched it up. They changed the composition of the entity applying for the contract. What do you have to say about that?
I could tell you the bid was $1.272 billion. That was accepted. There were the revenues of the three companies. Alvino was $282 million. Basilico was $548 million.
No, we know those numbers.
It went over $1 billion.
No, right. The question is, can an entity apply for a bid and then switch their composition, change the identities of the parties who are applying for the bid? And if so, is that something within the purview of the municipality?
Well, let me say this. Alvino affiliates, as far as I can determine, was made up of Wilkin Mechanical, J-Track, LLC, and MJL Contracting.
Counsel, can I interrupt you?
Going back.
Didn't also the DDC give notice?
Excuse
All
me,
potential bidders,
I didn't get that.
didn't the DDC give notice to all potential bidders that it wouldn't award a contract based on the bid alone, but there was a second step, correct? The pre-award process, correct?
There was a what?
A second step, the pre-award,
Yeah, yes.
so therefore there was time to sort out any typo on the bid
Yeah,
form.
there are times to do a lot of things, but this process goes on after the bid. You know, that's when they provide their financials, the audited financials. It's an ongoing process until they sign a contract. From what I understand, even then, there's still discussions. But it's a very flexible arrangement that the city has with their bidders. They're all experts that do this job. They're specialists in construction. They probably know each other from prior bids and prior businesses. It's a negotiating system that happens to work. And it's working, I'm told, it was beginning to work until there was a problem down there.
Okay, thank
Okay.
you. I think we got your position.
Yeah,
Thank you very much.
thank you.
Nice to see you.
Good to see you.
Mr. Cohen, you'll have 2 minutes for rebuttal.
Thank you.
So
For,
what about the standard that, I mean, you didn't talk too much about that, but this is a hybrid Article 70.
yes, I was about to address that.
Okay,
And what I was going to say is that I was going to request that you please give this a hard look like you always do. And I know the First Department always gives a hard look at the matters before you. But in this particular case, we brought in Article 78. There is no written decision. The decision was rendered from the bench, and it is our position it was, in effect, given short shrift. And we ask that this court please do so, and you will then find that the IPC bid, which was affected by an error of law, arbitrary and capricious, and lacked a rational basis, would grant our petition and send the case back. The most important factor for this court to please understand and
Counsel,
see
you've asked for an
is
alternative.
page
You've
98
asked for a
of the record. I'm sorry.
You've asked for an alternative remedy, which is to have the process, the contract rebid. What would be the benefit of doing that?
Pardon me, I couldn't hear the last part.
Sorry. You've asked that the contract be rebid as an alternative remedy.
Yes.
So what difference would that make?
Well, a world of difference. Factors can change. As you know, there's currently an issue involving the environment. The bid could change. Anything could happen. But to reject our bid based upon what has happened here is illegal, arbitrary, and capricious. And I would ask the court to please look at 98 of the record, which is the memo submitted by Iovino to buttress an otherwise failing bid. And that buttress was prepared, or that memo was prepared by Iovino. That was not a document that was prepared by the city, and it doesn't even contain the addresses of the partners, which must be contained. So I would ask you, please take a hard look.
as you said, we always do, and we will do that in this case. Thank you all very much.
Thank you.
And
It's a pleasure.
have a nice ride to the second department. I meant that for her, not to you. Thank you. Nice to see you all. Okay, the next case, now we'll go back to the top of the list, number 1, People versus Carl Ganey. Okay, counsel, good morning, you may begin.
Good morning, may it please the court. Anjali Patmanathan on behalf of Carl Ganey. I want to address 2 points in our briefs raised below, and the first is the weight of the evidence point. This is a case where it's a one-witness mis-ID situation, where the complainant was extraordinarily intoxicated during the robbery, and his initial descriptions of the robber was someone who was an Indian or Middle Eastern man, 5'6", 160 pounds with a thick mustache, whereas Mr. Gainey is a 5'9", 190-pound black man without any facial hair, as the pictures that I submitted to this court that were in evidence were presented.
Did Mr. Lin have photographs of the defendant?
Say that one more time, Your Honor.
Did Mr. Lin, the victim, have photographs of the defendant?
Yes, they
What-
took
What
selfies.
difference does that make to your argument?
Oh, that makes no difference, Your Honor. The victim took photographs, they took selfies together 3.5 hours before this robbery. The circumstances of that are actually really important because at that time, roughly around 2, maybe 3 o'clock, between 2 and 3 o'clock, the complainant and my client were drinking beers in a park. That was after Mr. Gainey had helped the complainant get a jacket from a homeless shelter at the Bowery Mission. At that point, the complainant says around 3 o'clock, they leave the park. He goes to another liquor store, buys some vodka, and takes a 16 to 18-minute walk to the Manhattan Bridge.
So if they had all that contact, which if I recall correctly, was at least an hour's time, then why would the victim be unable to make an identification?
Certainly, it's because of his intoxication, Your Honor. He started drinking somewhere around, by his own testimony.
Counsel, didn't the jury have before it evidence that he was not severely intoxicated, which they could credit?
They only had his testimony that he was not intoxicated, but that is not actually credible given...
What about the police officer who interviewed him that day?
Yeah, so the police officer said specifically that the complainant smelled of alcohol and was visibly appeared to still have been drinking. And I submitted to this court the medical records that the prosecution submitted into evidence, and those showed that the complainant, his chief complaint in the emergency room was intoxication, that he was currently suffering from alcohol abuse while he was in the hospital, that the medical staff couldn't conduct the proper physical exam or get his medical history because he was intoxicated.
But the medical record, the hospital record also said that the victim was awake and alert.
Certainly, being awake and alert doesn't change how intoxicated you are, Your Honor. And when he started drinking somewhere around 2 p.m. the day
So your
before...
contention is that he was intoxicated enough not to be able to make the identification, but alert enough in order for the staff to write that down in the record?
Yeah, no one's saying he was unconscious. We're saying that his memory was so impaired, or his intoxication so impaired his ability to recall the events. And I point to the 3.5 hour gap in his narrative.
Isn't it, I mean, somewhat unusual that the complainant and the victim would have spent that much time together and have pictures of each other spending the time together? So, I mean...
It's not much time at all, right, Your Honor? It's 45 minutes to an hour where the complainant had 2 large beers, which is 24 ounces,
But
which
they were
is 4
hanging out
regular
together,
beers.
they took pictures together.
But they're not friends and not long-term acquaintances.
understand
And what's really important is to point out the exculpatory identification that is initially in the record. Initially, this person that was described as the robber looks nothing like Mr. Gainey, who had an alibi for the entire time during the gap in time of the complainant's testimony.
Well, the description came from the joggers on the bridge, not from the complainant, correct?
Well, Your Honor, the
I mean, we can
complainant...
draw the inference, perhaps, but you could draw a contrary inference as well, that the joggers added their own embellishment.
Your Honor, I would submit that you cannot, based on the complainant's testimony, that he said he flagged down the joggers, he told them to call 911 because his phone wasn't working. So he was the only one who controlled the narrative of what was reported.
So the complainant didn't say that he told the joggers, that he provided the description to the joggers. Is that in the record anywhere?
There isn't a record on the trial transcript that the complainant provided that description, but I'll submit, Your Honor, that points to my other point in the briefing.
Well, in addition, let me just get this point out. The complaining witness had taken photographs, and isn't it accurate that he used some of those photographs to identify the defendant?
Yes, Your Honor. That's not disputed that they took photographs together. It's not disputed that Mr. Gainey and the complainant had met 3.5 hours earlier than the robbery outside of the Bowery
Well, when
Mission.
he identified the defendant in those photographs, it was for more than the premise that they spent some time and drank together. It was on the premise that he's the one that robbed them, correct?
Certainly, Your Honor, but that identification is certainly unreliable based on how intoxicated he was. And I'll just point out that in the 3-hour time gap, he doesn't
Photographs
recall.
weren't intoxicated.
Sorry?
The photographs weren't intoxicated. They serve as a record, do they not?
The photographs show how the complainant appeared at the time. I submitted them to your honors. You can see his face and make that assessment for yourself. At the end of the day, his medical record said he was intoxicated and only able to be released from the hospital at 3:30 a.m. the next day. So if the medical staff could not release him because they were awaiting his sobriety and monitoring him for sobriety 12 hours after he started drinking, clearly at 6:40, when he was robbed on the bridge and Mr. Gainey was home with his loved ones, the complainant was intoxicated, and it's a one-witness misidentification case where we submit that the verdict is against the weight of the evidence and has to be overturned.
Okay, counsel, you'll have 2 minutes on rebuttal. Thank you very much.
May it please the court, my name is Grace Fee. I represent the people. Regarding the issue on the weight of the evidence, the people would respectfully submit that the jury's verdict convicting the defendant of robbery was fully in accord with the weight of the evidence. The issue here is whether or not the defendant, whether Mr. Lin properly identified the defendant as the person who robbed him. And I would submit there was very strong evidence in that regard. First of all, I think as several of your honors have pointed out, this was a case where the defendant, there's no dispute that the defendant and Mr. Lin spent some time together. They were drinking together in the park. Mr. Lin even took selfie photographs of the two of them together. So there's no dispute that they were together and hanging out.
Counsel, didn't Mr. Gainey have alibi witnesses who placed his whereabouts at the time the robbery actually occurred? He was with his family, as your adversary said, with his loved ones at home.
Yes, Your Honor, there is. He did put on that defense. I would submit that the people, the jurors, I think reasonably rejected that defense. And I would submit the reasons why were because, well, first of all, they were loved ones. He was obviously, Miss Freeman was his long-term girlfriend. Elaji is someone who obviously viewed Mr. Gainey in a very, very close way, almost like a father figure. So I would submit, first of all, that it is understandable that they would perhaps be less than truthful about maybe the events of what happened really that day and whether or not Mr. Gainey really was home at that time during the crime. I would also submit that as the people argued to the jurors, and the court did charge the jury, is that you had to also look at what the alibi evidence here, when it was presented. Ms. Freeman testified that she was she followed this case very closely. She appeared at every court appearance. She was always in contact with Mr. Gainey's attorneys. She was there at his arraignment in February of 2013, where she heard what the crime was about, when it happened, the time it happened. And yet it wasn't until much later in the year, like 8 months later, that suddenly there was this alibi defense being presented and that she spoke to the ADA on the case. I would submit, and the court did charge the jury properly so that they could take that into account, the delay in the alibi defense. So I would submit that given those circumstances, I think the jury was right, or it was reasonable for them to reject the alibi defense. This just couldn't have been a case where there was misidentification. I don't even think there's any, there was never any suggestion on the part of the defense that Mr. Lin intentionally lied that the defendant robbed him. So was he mistaken? And I would submit that the evidence just didn't support that.
Counsel, for a moment, I want to focus on the 30-30 issue in this case.
Sure.
So there was a period of time, about 35 days, that was found to be excludable by the lower court. And that was pursuant to CPL 3034GI. However, when you read GI, there's a requirement there that that there be reasonable grounds to believe that such evidence here, the location of the main witness, will become available in a reasonable period. How do you satisfy that here?
Oh, yes. I would submit, and again, people did recount, I think, in pretty much detail, the hearing evidence that showed the efforts that were made by the people to try to find Mr. Lin, who was kind of like a
right, but the
semi-homeless
statute requires due diligence, and then it has this requirement of reasonable ground to believe that you're going to come up with the evidence in a reasonable amount of time.
Exactly. And
it's that second portion I want you to address.
oh, sure, yeah, sure. And I would submit it was reasonable because, First of all, I would just point out, it's kind of interesting that there is actually, it was a 56-day period involved here. It was from December 16th to February 10th. And yet, for some reason, the defendant seems to splice it. It seems to be that he's not disputing that the first 21 days from December 16th to January 6th, that was properly excluded. So in other words, I think the only inference that we can draw from there is that they're not disputing that there were reasonable grounds to believe that Mr. Lin, there was evidence that would support that he would be available in a reasonable period of time. It seems to be that they're only contesting from that 35-day period from January 6th to February 10th. And I would submit, when you look at the evidence as whole, as you should at the hearing evidence, I would submit that when you look at, for example, starting from December, end of December to January, shortly after January 6th, the evidence was that ADA Brooks testified that with the assistance of a Danny investigator and HRA, he was able to find out that Lin was using his benefits card in the Bronx and was housed at a program or shelter in the Bronx. And he was able to obtain a phone number from Mr. Lin, and then was able to contact him, and he was able to even visit him at the shelter in the Bronx. And when he did tell him that, there was a February 10th court date coming up, and explaining to him that it was on for trial again. And he said Mr. Lin was completely cooperative. I'm citing to page 52 of the People's Brief, but even on earlier pages in the brief, we recount, again, the efforts. And I would submit, when you look at the efforts that the people made, in whole, I think in that 56-day period, I think it shows that we were doing enough work to show that there was reasonable grounds to believe that this witness would be available in a reasonable period of time. And I would submit he actually was. Shortly after January 6th, by mid-January, we had located him. The next court date was actually February 10th. So we really did. I think that our due diligence also showed that we had very promising information that led us to think that we would be able to find Mr. Lin, and we did. We found him.
Thank you very much, Ms. V.
Thank you.
Counsel, you have 2 minutes.
Your Honors, the crucial fact about this 30-30 issue is that the trial prosecutor, conceded that these 35 days were chargeable to him. We haven't spliced the time period. The prosecutor himself spliced the time period because on January 6th, he admitted that the complainant was a ghost to him. They had no idea where he would be. Yes, they exercised due diligence, but it had borne no fruit. And so they were hoping for the best that the complainant would resurface. And the statute is abundantly clear. You need reasonable grounds to believe that the witness is going to return within a reasonable period of time. The prosecutor below must have understood that. I point directly to page 2 of their response motion, where the prosecutor lists 3 includable time periods, 35 days, includable to the prosecution. It's written in black letter, those January 6th to February 10th, 35 days. And those 35 days are dispositive. And when you look at the hearing, the 30-30 hearing, at the end of the hearing, the judge asks both parties if they have any additional arguments beyond their papers.
So, counsel, let me understand this. You're discarding the visits to the shelter address, the tracking down of the benefit card usage, the contact with HRA, you're discarding everything by simply saying there was no reasonable expectation that the complainant would surface?
There's 2 things, Your Honor. I'm not discarding any of that. That all establishes prong 1 of 2. And there's 2 prongs required to get this exception. And it's important to remember that it's the prosecution's burden to ask for the exception, and the trial prosecutor never asked for the exception for this particular time period. If you go back and look at their motion, they did not ask for the 30-34G exception from January 6th to February 10th. We're not disputing the due diligence. That was found below. They did do a lot of work to try to find this person, but ultimately, that's why there's 2 prongs. It's not just about how much work they did, it's about whether they had any reasonable grounds to believe he'd return. If the prosecutor himself never argued it, if the prosecutor conceded the 35 days below, there is no record of them asserting the 30-34G exception for this time period, and it's dispositive. It would have brought the chargeable days to 182 days, which requires dismissal. Thank you very much, Your Honors.
Thank you both very much. Okay, the next case is Lyman versus J.P. Morgan Chase, and Justice Moulton is recused from this case.
morning, Your Honors.
Good morning.
Joseph Dragna for Richard Lyman. May it please the court. Richard Lyman, a biological engineer, United States citizen while living in London, England, and a general partner in Healthcare Ventures, LLC, which, in addition to inventing medical procedures and/or products, also invested in companies that they thought were promising by purchasing shares of stock in those companies.
So counsel, I guess what kept coming up to me as I was reading through the papers and in this case is, what did Mr. Lyman do for 18 years while these stocks were sitting there? He never inquired as to what was happening. I mean, it seems what happened was a terrible thing, that the bank sold all the stock and he never knew about it. But during those 18 years, he never made any inquiries. He never looked at any statements. He never asked for anything from the bank.
Well, let me deal with those one at a time.
Okay.
First of all, did he look at statements? When Healthcare Ventures rewarded Mr. Lyman with 26,000 some odd shares of Shire Corporation,
Right.
pursuant to the laws of the United Kingdom, the stock was transferred to an entity that had a footprint in both the United Kingdom and in the United States, Hambrick and Quist.
Right.
Hambrick and Quist had a relationship of...
With the company, with Healthcare Ventures, but not specifically a direct relationship with your client, right?
That's correct. But the stock was transferred to Hambrick and Quist as a result of that relationship for safekeeping. And my client got a receipt first. That's what created the bailment, but it didn't open...
Counsel, the question is a little different. The question is, what happened during the course of 18 years with respect to Mr. Lyman? The money was apparently defalcated in the course of 1 week, subsequent to the transfer to the defendants, and for 18 years, he never checked the accounts?
Let me answer those questions, please, one at a time. The creation of the bailment didn't create an account. The criminals, the people who stole my client's stock, created the account. There was no reason for my client to examine an account that he didn't even know existed. Let's face it.
Wait. What do you mean he didn't know the account existed? I mean, he knew that these shares, he was getting these shares because he was a partner in HCV. So that's why he got those shares.
But the acquisition of the shares did not create an account. An account is created when there's a debtor-creditor relationship, but this was a bailor-bailee.
So where did
he got a receipt, a piece of paper.
That said, your shares are being held here?
Yeah, we're holding your 26,000 some odd shares of Shire stock, and that was the end of the
He never
bail.
inquired as to how the stocks were doing, if they were underperforming.
Well, obviously, he watched the stock grow. It's very clear from the complaint. You know, just because someone is provided with stock doesn't mean he has to sell it.
Well, I think what the counsel, I think what the issue for us, I mean, this is an issue of the statute of limitations, and it's really about what did he know or what should he have known and when should he have known that? As to when do we consider that the statute of limitations started running?
Well, how would a gentleman, Mr. Lyman, who is a biochemical engineer and who's given stock and is watching it grow in value by reading a newspaper or just watching how it's selling on the stock exchange, why should he make an inquiry? His only question is, when am I going to sell this? And the reality of it is, the stock is going up. Mr. Lyman, who's a brilliant biochemical engineer, is doing well.
Guess not such a great businessman, huh? Is that what you're saying?
Absolutely not. I can tell you that, and I've
I
told them
mean,
that a
I
million
think
times.
if I had $450,000 worth of stock, I would have checked on it in
Well,
18 years.
The stock now, as reflected in the summons and complaint, is worth $20 million or thereabouts. So he wasn't that stupid now, was he?
No,
He,
well, he didn't check to see where it was for 18
well,
years.
well, he did. Who said he didn't? That's not part of the record. The respondents have tried to inject that into the record, but it's not part of the record.
Okay.
What Mr. Lyman
So if
did
he
or
looked at it,
didn't,
counsel, when did he realize that it was no longer there, that it had been sold?
in 2018, when Lyman learned that
Well, that's 18 years later, right?
it is, obviously, it's 18 years later. But if I might say, with respect to the motion to dismiss, the case of Barada versus the Bank of Babylon and Kozlowski is very instructive. In that case, bonds were given to a bank, $120,000 worth of bonds, $100,000, $1,200,000 in bonds, were given over an 8-year period. And the president of the bank misappropriated those bonds, cashed them in, because he liked to gamble. And when Barada said, give me my bonds 8 years later, the bank raised the defense of the statute of limitations. Hey, you should have known that your bonds were sold.
Okay, well, does anyone else have any other questions? Well, you'll have 2 minutes for rebuttal. Let's hear from the
May I say one thing just quickly?
Very quickly.
Very quickly. This case fits well within the rule of CPLR 206A, subdivisions 1 and 2. Thank you.
Okay, thank you.
Morning, and may it please the court, Charles Keeley on behalf of respondent J.P. Morgan. The commercial division properly dismissed the 2-decade-old claims in this case based upon a straightforward application of the statute of limitations. If I may start by answering Justice Kapnick's first question to appellant, what did Mr. Lyman do for 18 years? The amended complaint alleges that he did absolutely nothing. The complaint alleges that the unauthorized transactions were in 2000 and 2001, and fast forwards till 2018 when he first inquired with the bank about the shares. He made no inquiry to the bank prior to that. He alleges that he made no inquiry to his own venture capital fund, HCV, about the shares. It is a
Well, I think the argument is that he had no reason to, right? Because he's watching the stocks go up, they're performing well. Why would he think that they're stealing his money? So why isn't it in 2018 when he makes the demand that we should start counting the statute of limitations?
Well, two responses to that, Your Honor. First, it's a basic principle of law that a conversion or a breach of contract claim accrues at the time of the wrong, not at the time that the plaintiff discovers the wrong or should have discovered the wrong. So even if he didn't have to do anything, didn't have to check any account statements or ask any questions, the claim still accrued back in 2000 and 2001. This court, in its 2015 decision in Stern versus Morgan Stanley, found that with respect to a fraud claim, and there you have a discovery rule where it's 2 years from when the plaintiff discovered or should have discovered the fraud, that an account holder who either does not receive account statements or makes no inquiry about the non-receipt of account statements cannot establish reasonable diligence to take advantage of the 2-year discovery rule. This court stated that it was, quote, fatal to the claim of reasonable diligence. So that covers all the claims that he asserts in this case. And just to address a couple other points he makes, CPLR 206A expressly provides that it applies, quote, when a demand is necessary for a person to bring a cause of action. It's well settled, and we cite over a dozen cases in our brief, none of which they respond to in their reply, that a demand is not necessary when a custodian of property, including a bank, unlawfully transfers the property, and that immediately gives rise to a cause of action for conversion or for breach of contract, and no demand is necessary, and CPLR 206A is not applicable in those circumstances. The Commercial Division also properly found that plaintiff had not established or alleged any basis to equitably toll the statute of limitations. Again, this case, this court's decision in Stern versus Morgan Stanley holds that an account holder cannot establish reasonable diligence if he does not receive account statements or make an inquiry if he fails to receive any account statements.
And there's no claim that the plaintiff reviewed any statements in those 18 years?
That's correct, Your Honor.
And you didn't, I mean, it seems that you never sent him any statements, which seems hard for me to understand how you hold somebody's shares and don't send any statements, why they only went to the company when they were his shares by that point.
Your Honor, those facts are outside of the complaint. The complaint affirmatively alleges that plaintiff received no account statements. So for the purposes of our motion to dismiss, we accepted those facts as true and established that the claim was time-barred as a matter of law, notwithstanding that fact. There was also a cross motion for summary judgment brought by appellant, and in connection with that, account statements were presented to the court.
But they weren't authenticated, is that what the problem was?
Well, yes, Your Honor. We submitted those account statements through an attorney affidavit rather than a business records affidavit, so they weren't authenticated. But that is irrelevant because the court granted our motion to dismiss, in which we affirmatively told the court, you need not consider any facts outside of the complaint. You assume for the purposes of the motion that plaintiff received no account statements, and we demonstrated that the claim was time-barred as a matter of law.
Any other questions? Okay, thank you very much.
Thank you.
Counsel, you have 2 minutes. May I? Yes, please.
CPLR 206A2 specifically says, when a bailment is created for not a specific time, the statute of limitations, quote, it expressly says the statute of limitations doesn't run until a demand is made. In this case, my client made a demand in 2018. What counsel has just said in terms of the so-called account records is, it doesn't matter how the records came, and that's clearly violative of the law. If you're going to rely on records, introduce them as records kept in the ordinary course of business, and say that it's in the ordinary course of business to keep those records. But he didn't do that. His client didn't do that. As a matter of fact, his client did just the opposite. And the truth of the matter is, these records were not part of J.P. Morgan's base of records. We don't know where these records come, but they didn't come from J.P. Morgan. They came from someplace else. They came from someone within the bank. But that doesn't mean that there were records kept in the ordinary course of business. And the respondents argued records which appear to have been created by criminals, not in due course. How can the respondents argue using records that were brought into life by criminals? And that's what they're doing here. That's what they've done. Okay? They say that Lyman should have known that there were records, but bailment didn't provide the records. If the stock was sold, who stole it? The criminals. And whose name did they put it in? Lyman's name. Not in the criminal's name, Lyman's name.
Okay, I think we got your argument. We'll take another look at the papers. Thank you both very much.
Thank you.
Have a great afternoon. The next case for argument is Bank of America versus ASD Gem Realty.
Good morning.
Morning.
May it please the court, I am Adam Browser for the Appellant Sweet Construction Corp. As best as I can tell, this is a case of first impression. It involves a section of the General Business Law, 756-A3B, Roman numeral I, that is part of the Prompt Payment Act. That law went into effect in 2003, even though 18 years has
Counsel,
passed.
since the enactment of that law, haven't courts continued to say that pay-when-paid provisions violate public policy per Blandford and other prior precedent?
Yes, courts still enforce the Westfair Doctrine, which invalidated pay-when-pay clauses. There has been no case that has interpreted the statutory section that's present here, and in fact, there really is no conflict between the General Business Law section here and the Westfair Doctrine. If there were to be a conflict, and no court has ruled on that, I haven't found any cases that interpret it. Respondent's brief didn't cite to any cases, and motion term below didn't cite to any cases. When Westfair and the pay-when-paid doctrine is invoked, it's under different circumstances and different contract language. If there were to be a conflict between the General Business Law and the Westfair Doctrine, well, then I would submit that the statute has to control over the judicial holding. But there is no conflict.
Sorry to interrupt, but did your client, did it say that it was an agent for all purposes or only for payment?
For payment purposes, as I recall the contract.
But doesn't the statute take a more comprehensive view? So for example, if Sweet had said, we're just signing this on behalf of ASD, ASD will be passing on your change orders, which didn't happen here. ASD will be managing the contract and telling you how to do your work. That would be, to me, perhaps, a contract that might fall within the statute. But here you have a hybrid.
Well, I don't see a difference in the distinction that Your Honor is making, because ASD, the owner, as most owners, do not have the capability to manage a construction project. And that's why they hire general contractors or construction managers to deal with the subcontractors, deal with scheduling, deal with processing payment requisitions. And, you know, as proof that the respondent was always looking to the credit of the owner, ASD, and not to Sweet, is simply in the way the parties managed the project.
Counsel, we were discussing how there haven't been any cases that interpreted the section, notwithstanding that it's been around for 18 years. And I was wondering if you looked at any legislative history. Sometimes the legislature does enact things to respond to what the cases are saying, saying we don't want this case law to continue, we're going to change the law. So was there anything in the legislative history, I have to admit I did not have an opportunity to look at it, that says this is in response to the Westfair and subsequent cases that say pay when paid is against public policy? Because this seems to be going back on that.
Well, I looked, Your
To some
Honor,
extent.
and I didn't find anything either for or against the position. If I had, I would have referred to it, but all that there really were statements in support of the legislation. But the language, as far as I'm concerned, in the statute, when married with the language in the subcontract, is clear on its face that there should have been a ruling in favor of Sweet. Yet motion term rejected that, and in doing so also violated statutory rules of construction, which say when the statute is clear on its face, it should be applied. To come back to the Westfair issue, Westfair is concerned about preserving the rights of subcontractors to file liens. And this contract and the General Business Law statute does not impair that. In fact, the respondent did file a mechanics lien here. The respondent did commence an action to enforce its mechanics lien. It just ultimately wasn't successful, not because of Sweet, but because of the presence of the construction lender's lien, which ended up usurping all the proceeds of the foreclosure sale. So the lien law in Westfair provides a remedy to a subcontractor, which the subcontractor availed itself of here, but it's not a guarantee. If the court has no more questions, I'll sit down.
Well, you will have 2 minutes for rebuttal, so let's hear what your adversary has to say.
Yes, thank you, Your Honor.
Thank you very much, Counselor.
Good morning, Your Honors, and may it please the Court. Janissa Urbano from Clark Golden Attorneys at Law for Respondent Aronson Office Furnishings, Inc.
So, counsel, how do we get by that third sentence in the, it's not really newly elected, but 18-year-old statute? We thought 18 years was old in the last case, but it all depends, I guess. In any event, how do we get by that third sentence, which seems to allow what Westfair said we shouldn't allow?
Well, Your Honor, in order to get by to the third sentence, it means you also have to completely ignore the second sentence, which is performance by a subcontractor in accordance with the provision of its contract shall entitle it to payment from the party with which it contracts. That was sweet. Aronson contracted
but then it
with
says
Sweet.
notwithstanding this, and it goes on to say that. It's a very, to me, it's kind of confusing, but.
Well, it's less than clear, Your Honor, or obviously we wouldn't be here today. But the established public policy of New York is to strike down pay-when-paid provisions. As His Honor pointed out, there are numerous cases post-enactment of this statute, and well post, not just in the 03, 04, 05 timeline, but as late as 2015 and 2018, that uphold those same principles, that pay-when-paid can't stand and is still void and against public policy. And in fact, the statute, those cases don't just talk about lien rights. They talk about a reasonable amount of time with which a subcontractor needs to be paid. They actually find in one case that 2 years was too long, another case that 3 years is too long. The statute itself that Sweet relies upon also talks about timing of payment. Part of the statute says that the contractor or subcontractor shall disclose at the time of the subcontractor is entered into the due date for receipt of payment. So timing clearly is a concern of the legislature. Timing continues to be a concern for the courts. And here, Aronson has waited nearly 6 years, and the trial court, well, I submit, found properly that that was an unreasonable amount of time to wait to be paid by the party with which held the contract, and that is Sweet. The owner here didn't even sign the contract as acknowledging the one provision that Sweet tries to rely upon. For those reasons, I submit that the trial court acted properly and the motion for summary judgment should be allowed to stand.
Any other questions? Okay, thank you very much.
Thank you, Your Honors.
We'll allow you 2 minutes to respond.
I just want to talk about what the contract was in this context. It consisted of 3 documents. It consisted of the proposal by the respondent directly to the owner, because they had some pre-existing relationship, presumably from other projects. It wasn't addressed to Sweet. That's 1/3 of the contract.
I mean, the owner in this case kind of picked Aronson and said to Sweet, this is who I picked to do the partitions, enter into a contract with them, right?
Absolutely, Your Honor, absolutely. Of the 3 items that form the contract, there's not a single provision in any of one of them in which Sweet says, I will pay you based on my own funds, my own financial ability. It is coming from the owner. That was always the understanding, always the expectation, and that's why the payment requisitions from the respondent are directed to the owner, and that's why the lien waiver from the respondent says upon a receipt from a check by the owner, and that's why there's a letter in the record in which Sweet tells all the trade contractors that the money's coming from the owner's construction lender, and we are going to disperse it. And then
When I asked counsel about, well, how do you deal with that third sentence, she said, well, you know, but you got to get past the second sentence. It seems that these two sentences almost conflict with each other. How do we reconcile this statute?
The third sentence starts by saying, notwithstanding this article. So it basically says, you know, regardless of what that second sentence is, if the general contractor and the subcontractor enter into this relationship where the general contractor is the agent for a disclosed owner, this is to me, you know, principal agency 101, then the payment obligation flows directly from the owner to the subcontractor. The GC, the general contractor, is merely an agent. And that's why this can be reconciled with Westfair. The debt is due to the subcontractor, but directly from the owner, and the subcontractor can and did file a mechanics lien. The statute and the subcontract adhere does not violate Westfair.
Okay, well, thank you very much. Very interesting, and we will certainly take a look at it.
Thank you, Your Honors.
Have a great day. The next case for argument is GFE Jerome Avenue versus Stepley Associates. It's weird. Okay, good morning.
Good morning. May it please the court, I'm Eugene Myers for Appellant GFE Jerome Avenue LLC. This is a fairly straightforward case of contract interpretation, and it was within the power and authority of the lower court to interpret the contract as a matter of law.
But didn't the courts find that there are an awful lot of issues of fact here? That was the problem. I mean, well, of course, the court didn't say very much of anything, but it does seem that there may be quite a bit of factual issues here, not just contractual interpretation. Like, what happened with Con Ed and the defendant, and how did this, you know, what happened with this gas line? Who turned it off?
Well,
I don't think, it wasn't that clear to me.
Right. The central issues in this case, there are no material disputes of fact. The lease provided that the landlord was required to provide gas service supplied through a two-inch line.
Counsel, Justice Kapnick mentioned Con Edison, and isn't there also a regulatory overlay that is sort of like a cloud over this lease? Because the lease provides for a 2-inch hose, gas hose, and apparently Con Ed said no, they need a 3-inch gas hose. And also, I mean, the requirements of Con Ed in this situation appear to create issues of triable fact. And tell me why that's not the case.
So a few things. One is that the lease provided, the main primary purpose is to provide gas service. Now, there is a specification for a 2-inch line, and that 2-inch line is actually supposed to be the line that's delivered into the premises. So the landlord is supposed to deliver the premises with a 2-inch line of gas service in the premises. The 3-inch line that the respondent is referring to is a line that's non-functional, that is in the cellar of the building, that is later then connected to a meter, which is then connected to a 2-inch line to the premises. So the 3-inch determination that is being referred to is really nothing to do with the lease language that states that it has to be gas service supplied by a 2-inch line. And in any case, there's no record of any Con Ed determination other than statements made by the respondent, and even in the records that are provided by Con Ed, they state that there is a determination that the existing gas line is sufficient, and there's nothing in there that says anything about the 3-inch determination. But that's all really extrinsic to the contract, which on its own can be determined whether there has been a breach, because it's very clear and unambiguous that the landlord was required to provide gas service. Now, whatever that required to do, whatever tasks were required to achieve that, whether that was a meter, a new pipe, a new valve, whatever had to be completed by the commencement of the lease. And that commencement.
But wasn't there some allegation that the way that the pipe was connected sort of led someone to say that you were stealing gas from another subtenant?
So there's,
Foot Locker, I think Foot Locker had the other. half of
right,
the
so I think there's a little bit of a confusion because, and I would say that the respondent created some of that confusion in its briefing, but there's an existing line in the space when the tenant entered when the landlord delivered the premises, there was an existing 2-inch operating gas line. And the tenant believed that that was the line that was intended for its use under the landlord's work requirement. It turned out, according to the landlord, that the tenant was not authorized to use that line, and so therefore there was no gas line at the commencement of the lease that was for the tenant's use. So right there was a breach. Regardless of whether or not they were allowed to use it or not allowed to use it, at that moment, there was a breach of the lease because the landlord did not deliver the premises with a gas line, any gas line. It was only later, in 5 months later, that the landlord cut that existing gas line, which apparently the tenant was not authorized to use in the first place, and then replaced it with a non-functioning pipe in the cellar that's not demised to the tenant. And in that cellar of the building, there was this 3-inch, not connected to any gas service, that clearly was not installed at the commencement of the lease. If the landlord was not able to deliver the premises with its landlord's work completed, then it shouldn't have agreed to do so in the lease under the commencement, before the commencement date. Obviously, it was within the landlord's power to determine whether it could achieve what it promised to do in the lease. And if it couldn't, then it shouldn't have agreed to this. The parties wouldn't have agreed to a 4-month rent concession, which 4 months was based on the fact that there was supposed to be a build-out of this restaurant for 4 months. And if there was no gas service, that was the main purpose of that 4 months, is there would be gas service, and therefore there would be enough time. If there was no gas service, the 4 months would not be enough time, and therefore the tenant would require further rent concessions if it knew that there was going to be no gas service.
Okay, why don't we hear from respondent, and then you'll have a few minutes to respond. Thank you.
Good morning, Your Honors. If it may please the Court, Kenneth C. Henry Jr. for the respondent appellant. First, there's nothing in the lease which provides for the landlord to provide gas service. The lease was clear.
Well, it says that you should provide for a gas line. So what else are you supposed to do with the gas line except provide gas service?
Gas 2-inch line is what was supposed to be provided, not gas service, not gas with a meter, and the landlord efforted to get a gas line.
Well, how did that, I mean, what is your position as to how that gas line got locked off? Because there is a picture in the record of a lock so that they couldn't get any gas, which doesn't seem to make much sense. It's a restaurant, and they had to start using all kinds of electric equipment. But it doesn't make sense to me. So how did that happen?
The gas line was locked by Con Ed, as stated in the affidavit of the plumber who witnessed Con Ed lock the gas line. The landlord did not lock the gas line.
At whose direction did Con Ed act, though? Isn't that a question? Don't we have a lot of questions of fact? I mean, the more I listen to you and your adversary, the more questions I have. And I've written a whole bunch of questions down here. How did Con Ed get on the premises? Why was the line locked?
Well, in terms of the landlord complying with his obligation under the lease to provide a gas 2-inch line, the landlord contacted a plumber, and in those conversations it was determined a 3-inch line would be needed. The plumber and Con Ed working together then determined a line was inserted from the street into the basement of the building. And when Con Ed did that, they locked the gas line that was going to the demised premises. The landlord was trying to comply with the requirements of the lease. And with regards to that, there's been a misnomer that at commencement date...
Yeah, counsel, let's talk about that. How much time did the landlord have? Could they have taken a year to do that?
Well, unfortunately, commencement date and what was supposed to be provided at the time the landlord took
commencement date is not defined. You're right, it's not defined, but shouldn't we give it a practical application that it's the date that they move in, April 9th, or the date the lease was signed, April 4th, whatever it was? I mean, what's your definition? Does it mean anything?
It does. It was to do it in a reasonable time, which they did by September.
Could you do it a year later? That's my first question, I guess I asked.
Could it have been a year later?
Yeah.
No.
Okay, so could it have been 6 months later?
No.
Okay, so what's your definition then?
A reasonable time. The gas line was inserted and ready by September 14th, 67 days before the tenant was going to open up.
Or roughly 4 months after the lease was signed-ish?
Well,
5
the
months?
lease was signed in April, but the keys were not delivered until May 9th. So,
But you say a reasonable time was September 14th, but that's the day that the lock was placed on the gas line. I thought that your Maxwell Plum Mechanical Corp. Plumber said that he witnessed Con Ed tap the gas line.
there's two different lines. There was a line inserted by Con Ed for the use of the tenant, and the other gas line that was down in the basement had to be locked. That line was connected to a meter which had an account for another tenant. So therefore, Con Ed locked the gas line so that the tenant could not illegally take gas, and the tenant never tried to open an account with Con Ed. They never made provisions to pay for gas.
All right, we'll hear from, thank you, we'll hear from the other side. You'll have 2 minutes also. May I ask you, counsel, what about the roof leak situation? That's another part of this. There seem to be some differing views as to who had access to the roof and who was up there doing what.
Right, so I think the roof is very clearly, and we agree with the court's determination that there are issues of fact with respect to the cause of the leak. I mean, the lease provides that two relevant provisions regarding the roof. One is that the landlord was required to deliver the roof in a water, or the ceilings in the waterproof condition. And number two, if there are any repairs required on the roof, the landlord was responsible for repairing the roof, with one exception, if the tenant caused the damage to the roof, excuse me. The respondent has not provided any competent evidence, let alone expert testimony, which is required by, in an earlier decision this court found in Safe Haven Properties LLC, that an expert is required in order to determine the water infiltration, the cause of water infiltration. The respondent has not provided that kind of evidence, and there's really no competent evidence to determine what is the cause of the leak. And the application of the theory of res ipsa loquitur is not applicable here, because that theory is limited to cause of action for negligence, and in addition...
Hope we don't get any roof leaks today.
Is that the rain?
Yeah.
Oh,
Sorry.
my
All right,
goodness.
and in addition, the tenant was not in exclusive control of the roof. As in the record, it provides that the roof is accessed through the neighboring tenant's store, Foot Locker. So clearly, this roof, first of all, it's shared by multiple tenants. Second of all, this tenant, GFE Jerome Avenue, did not even have direct access to the roof. It had to access it through another store. So clearly, that res ipsa loquitur theory is not applicable for multiple reasons as a matter of law. Now, just to...
Counsel, can you just address what your adversary was saying with respect to the 3-inch pipe? Your adversary maintains that all the problems that the plaintiff is experiencing have to do with the mere fact that it neglected to open up a Con Ed account.
So the respondent oversimplifies this process of opening an account. In order to have gas service in a space, clearly you have to have an account with Con Ed. But in order to open an account, you have to have all the required construction to be completed so that you could provide all the information to Con Ed that's required and all the gas pipes to be tested in order to open the account. So it's not simply filing a piece of paper. However, one is opening an account when you have an existing line in your premises, which the landlord was required to provide, stubbed into the premises. It's another thing when you have a pipe in the basement of the building that's not connected to anything. That's a whole other process with respect to Con Ed. They have to come in, install a meter. The tenant had to install gas piping in the cellar of the building, had to do all sorts of work that was clearly not what was intended under the lease, which specifically said the landlord was required to deliver the premises with gas and a 2-inch line. Now, if it cannot be possible that what the landlord did, which was this 3-inch non-functional pipe in the basement, could have in any way complied with the lease.
Okay.
There are no further
any
questions.
further
Thank you.
questions? Okay, thank you very much. We'll hear from you for, also have 2 minutes for rebuttal. Whoops, counsel, can you just, yeah. Thank you.
If I just may address one point. The plaintiff knew that there would be a gas line installation, and they said that by their attorney's affirmation when he said, on January 25th, 2018, my partner Ralph Stone sent Mr. Aaron a revision to the proposed rider incorporating landlord's gas line installation requirement. The landlord did exactly what he was supposed to do. He tried to install a gas line for the plaintiff. Any further questions, Your Honors?
Counsel, when Burger King was in that space, wasn't there a subtenant of Burger King that piggybacked off the line just the way the plaintiff in this case wants to piggyback off the gas line?
That was entirely different. In the beginning, this whole premises was Woolworths going back many years. And then when Woolworths went out of business, there was a common owner between the two spaces. What Woolworths did and what the next owner did had nothing to do with the landlord. The meter was in the name of Foot Locker. It wasn't in the name of the landlord. So, and the tenant never made an attempt to make an agreement to pay for gas. They didn't go to the other tenant and say, can we divide up this bill? And gas can't be submetered. That's not allowed to be done in New York City. So what happened before, candidly, is irrelevant to what happened at this point in time.
Is there anything else you wanted to say about the roof leaks, or?
With regards to the roof, there were no leaks in May, June, July, August, September, October, November. During that period, the tenant went up and cut holes in the roof and had their workers up there traipsing all around. After they do that work, that's when the leaks occurred.
What about, does it create an issue of tribal fact, Mr. Ahmed Fawed's affidavit? Their engineer, Mr. Fawed, said that he pointed out to somebody from your shop that there were stains on the roof or there was apparent leakage in the roof. He said he pointed that out in April. So doesn't that create an issue of tribal fact?
With regards to that, I don't remember the record exactly, and I don't know if this is in the record, but from speaking to my client, those stains came from when a condenser had an issue, and that's where those stains came from. I'm not sure that that is in the record, though, Your Honors. I do apologize. I can't reach right to that.
Okay, well, thank you both very much. We'll take another look.
Thank you.
The next case for argument is Ingrati versus Avalon Bay.
Good morning, Your Honors. Jillian Rosen for the Plaintiff Appellant. In this case, the trial court erred in dismissing plaintiff's 241-6 case based on 1.7E2 and in denying summary judgment to the plaintiff. On the Carrera case, the Carrera case is entirely distinguishable. In Carrera, the plaintiff, by his own testimony, testified that the ground was entirely composed of dirt and rocks. It was intrinsic to the work area. So in that respect, plaintiff was denied summary judgment under E2. Here, the photographs really tell the story in tandem with the deposition. I'd like to just refer you to some photographs and discuss the deposition testimony, because the defendant's deposition, their admissions basically establish the propriety of our claim under 241-6. If you look at 1372 of the record, there are 3 photographs. One is F on 1372, one is C on 1373, and then there's D on 1374. If you look at 1372 first, that's Exhibit F. The plaintiff testified, if you see the circled area, that the broken up cobblestones and bricks is where he tripped over and fell. And Brocknier, who is the witness for the defendant, testified at 500 to 504 of the record that this area represents the area where plaintiff was working at the time of the accident.
Well, I'm looking at 949, which
Yes.
I'm not, that's Exhibit I'm not sure.
Okay,
I don't
not-
have the whole record with me.
Okay, so 949
And
is
that
actually,
seems, I mean, I think what you're trying to say is that there's some debris and it's I mean, it certainly looks like the road is
Yeah.
broken up and there's debris there.
yes, 949 is actually a more expansive view. You don't have, you don't have volume 3 with you? Okay, because.
Well, we
it's-
don't have anything in paper anymore.
Okay,
And we don't,
so
it's
in
hard
any-
to pick it up
Okay,
as I'm
well,
talking to
then
you.
I would ask you to, okay.
I'll look at it.
949 is what 1372 is. But if you look at 1372 to 1374, they're color photographs and they're terrific. And they show, more importantly, they show that the surrounding area is concrete. It's sidewalk. It's not all bricks and dirt and debris and rocks and cobblestones. And the defendants testify to that. In fact, Brocknier at 509 testifies that the area surrounding the dirt and debris that he fell on was concrete sidewalk. This is not a situation where it's all dirt and debris and you can't distinguish where you fell, which is what the case is in Carrera. So those photographs, you know, the defendants testified there's concrete, broken rubble, broken cobblestones and brick, that it's uneven, that it's a tripping hazard, that the area surrounding the dirt and debris is concrete sidewalk. And in addition, you don't have it with you, unfortunately, but at 1336 of the record, I'd ask you to look to 1336 to 1346 of the record. These are photographs that were taken by Mr. Induzzi, who is a co-worker of the plaintiff. And these photographs are even better. These photographs show that the ground is a mixture of concrete and the broken up cobblestones, but it's even better. It shows that the concrete is smooth and it's level in all the areas except for this dirt and debris and cobblestone over which he fell. And then Induzzi also admitted at 1232 and 1235 of the record that this area is not just dirt, but it's concrete also. So you have a situation that's entirely distinguishable from Carrera, and it's undisputed. The defendant's own testimony establishes prima facie plaintiff's claim under 241-6 based on 1.7E2. It's not integral to the work. It wasn't integral to the construction. And this was the defective premises condition, of which, by the way, I may have to wait till my reply, but on 200, which is an extraordinary, this is an extraordinary, as rare as it is, it's an extraordinary 200 case, because the defendant testifies at 541 of the record that he admits that this condition, the area that is shown in these photographs, existed for 2 to 3 months prior to the incident, but he did nothing about it because it was a high trafficked area, which in my opinion is all the more reason to take care of it. But this was known to the defendants and nothing was done about it, and it is clearly an area that is dirt and debris with concrete surrounding it. So our position under 241-6 is that summary judgment should have been granted at the very, very least. The defendant's motion under 241-6 should have been denied.
And the court below did not dismiss your 200 case. You just are looking for
No,
partial summary judgment on liability on that.
Correct.
Right?
I can address that on reply because I think that my time is up.
That would be fine.
Okay,
Thank you very much, Ms. Rosen.
Thank you.
Good morning, Your Honors.
Good morning.
Matthew Bremner for Harrington, Acco, and Monk, for the respondent, Avalon Bay Communities, Inc. If it pleases the court, Your Honors, contrary to plaintiff appellant's contentions, the clear photographic evidence in this case clearly and firmly establishes that the condition that plaintiff alleges caused his injury was, as the trial court found below, quote, a small patch of uneven ground surrounded by chipped and cracked bricks or concrete that are part of the ground surface itself and or wholly embedded in the ground
Counsel,
surface.
I'm looking at the photograph at 949 of the record. It's the one that shows broken bricks, broken concrete, dirt, and also what appears to be cobblestone. So how do you explain the appearance of cobblestone as debris that's normally found in a construction area and that therefore can be disregarded under Labor Law 241-6?
Your Honor, those are artifacts embedded in the surface of the ground in that area. They are pre-existing parts of the surface in the ground in that area.
So if they're pre-existing and it's cobblestone, it wouldn't necessarily follow that it's not a deep hole, right?
Your Honor, you have to look at the industrial code section that is
No,
being...
I'm just talking from the perspective of common sense and being a New Yorker. Cobblestone isn't normally on the surface of a walking area unless you're in the street. This is on the sidewalk proper, which is the working area.
Well, Your Honor, when the street is cleared to convert it to a driveway, there are areas of the street that are basically cleared, areas such as tree wells or other fixtures on the street that are cleared. With respect to this specific area, though, the fact that there was cobblestone in this particular area of the street, and the record's really not developed on that point, doesn't change the fact that those cobblestones are in fact part of the surface of the ground in that area. It really
Counsel,
doesn't...
can the photos be interpreted to show that the lighter pieces of concrete, which are whiter, can be the construction debris, the cement that might have fallen off a truck or whatever appliance they were using to transport it, and it was left there, and that could be the debris? Can we interpret the photos that way?
I don't believe so, Your Honor. I believe that the witness's testimony, Mr. Induisi, who took the photographs directly after, was asked about the concrete and the bricks at his deposition, and he said they were part of the ground and in the ground in that area. With respect to Industrial Code Section 2317E2, that section talks about accumulations of dirt and debris, scattered materials, or sharp projections. It does not deal with defects or misleveling in ground
No, you're right. I mean, the question really is this debris or is this supposed to be what's in the street? I'm not sure that Mr. Induzzi, you know, can just say that and then we all have to say, yep, that's it, cobblestones, bricks, all that belongs in the street. I mean, I think there may at least be an issue of fact. I know, I mean, I think that's what plaintiffs, she would like us to grant partial summary judgment, but at least find that there's an issue of fact as to that. I mean, the pictures do seem to leave open the possibility that it might be more than what Mr. Induzzi, I'm not sure how he knows what is, you know, indicative, you know, what would be definitely in the street before. I don't know, but if it looks like some debris to me, looking at the picture, and this is a pretty good picture.
Your Honor, our contention is that what the photographs do show are actually the surface of the ground in that area. There is some misleveling, but that is not addressed under Industrial Code Section 2317E2. That's something that plaintiff has raised in the common law, Section 200, general negligence claim. With respect to that claim, constructive notice is not the only issue when you're analyzing a claim under Labor Law 200. More specifically, you have to look at whether that condition is reasonable given the overall context of that area and that site, and whether the employer undertook reasonable measures to maintain the site in a reasonably safe condition. And that area, I would just point out, Your Honors, is an open outdoor driveway used to facilitate heavy construction deliveries, and it's an area that plaintiff was specifically stationed in to oversee and direct traffic through. Thank you, Your Honors.
Okay, thank you. Ms. Rosen, you have 2 minutes.
Your Honor, Induzzi never said that this was part of the ground. That's number one, but you could see that in the testimony. I want to point out that the testimony did establish that prior to the concrete being poured, there was excavation and foundation work, and what that involved was ripping the sidewalk and ripping any tree wells that was appropriate to be ripped out of the ground. And so there is no indication. In fact, it's almost undisputed that this area was concrete and that whatever was removed from the excavation or the demolition or the stripping of the sidewalk was supposed to be cleared before the concrete was poured, and that at that time, the ground, the surface is the concrete. So you will see that in the deposition testimony in our briefs. I just want to touch upon 200 for a minute because it really is, I know it's rare, and this court has held in Langer that it's very rare to get 200, summary judgment 200, but it's very appropriate here for two reasons. Number one, as I alluded to before, at 540 to 541 of the record, Brocknier, who is the defendant's witness, now remember, the defendant is the owner and the GC here, so there's no issue. They supervised and controlled and was in charge of everything. He admitted that 2 to 3 months before the accident, this condition looked the way it was. And as we know, a defendant who fails to act in response to a defective condition of which they have notice is liable as a matter of law under your court precedent, but especially in Langer and Wennick and Hewitt, which are all in our briefs. And here, there's no conflict at all in the evidence. There is no issue for a jury to decide as to whether the defendant violated their duty to maintain this premises in a reasonably safe condition. The defendants admittedly had actual notice of this for 3 months. So it's our position that 200, we recognize that the court denied their motion, and of course that was proper. We feel on this record that 200 should have been, the plaintiff should have been awarded summary judgment on 200, as it's undisputed that this was a defective condition of which the defendant knew and did nothing to do to remedy it. If you have no questions, I'll rest on my brief.
Okay, thank you very much.
Thank you very much.
both.
Have a nice weekend.
You too. The next case for oral argument is Medina versus 676 Hunts Point Realty Corp. Okay, counsel, you represent 676 Hunts Point, correct?
Yes, Your Honor.
Okay.
May it please the court. My name is Stephen Verveniotis. I represent the property owner. I think it's appropriate to mention one procedural issue. The motion was made on the basis of the documentary evidence of the lease and the assignment for determination as a matter of law. What you'll hear in the cross appeal and the arguments in opposition, they've raised all kinds of things outside of the documents, things like whether in having this vacant lot where they parked cars, they caused the condition on the sidewalk. That's not my motion. Another thing that they argue is that there's a duty to the plaintiffs regarding the sidewalk. I didn't move as against the plaintiff to dismiss the plaintiff's case. My sole legal argument to the court below was that there's a lease and an assignment. There's 2 tenants, an original tenant and then the successor tenant, which I argued as a matter of interpretation of the lease in the first instance. We'll get to whether they caused the condition when we get to depositions and other issues, but my first legal argument to the court is, do I have to go that far and do depositions? Can we look at the lease? The lease in this case—
You wanted contractual and common law indemnification from both of the tenants.
As against both the tenants.
Right.
To get to the second issue first, because it ties into the first issue, when the assignment doesn't specifically say that the assignor tenant is released, they're trying to imply into that it's released. I think as a matter of law, if it doesn't say you're
Counsel,
released—
isn't the more fundamental problem that paragraph 29 of the lease refers to the sidewalk only in the context of snow and ice removal? Isn't that a problem for you?
No, Your Honor, because it says all repairs, and then it also says further on in the lease that all statutory obligations, page 94 in the record talks about that the plaintiff shall comply with all statutory obligations with respect to the premises or connected to the premises.
Talking about all repairs, that's to the leased premises. I don't think they leased the sidewalk. So I don't think that helps you.
Well, you can't lease a sidewalk. It belongs to the city of New York. The case law talks about and the lease talks about who's going to be responsible, as I say, under paragraph 2 of the lease, which is in the record, page 94. It talks about maintaining the, even connected to the premises.
But counsel, well, if you look at the lease writer where you see paragraph 29,
Yes.
there really is a separation here, isn't there? Where you see the tenant herein agrees that it will be solely responsible for all repairs to the leased premises. And the leased premises is not defined to include the sidewalk, as you say. And then there's a stop because there's an and. And further, shall solely be responsible for the maintenance of the subject premises. And then it says, including but not limited to the ice and snow on the sidewalk in front of the premises. That you don't you need specific language requiring maintenance of the sidewalk if that's what the landlord, the owner, truly contemplated here?
Well,
I mean,
first,
I'm just
first
doing
of all,
basic statutory construction. It says what it says.
I think including doesn't mean it adds to all repairs. It makes clear that all repairs means all repairs and says including.
But it
I don't
doesn't
think-
say solely responsible for all repairs to the leased premises and the sidewalk.
Yes, Your Honor, it doesn't say that there. But in paragraph 94 that I referenced, the tenant has the obligation to comply with what we're really talking about is statutory requirements regarding connected to
But
the
you would
premises,
agree,
a
you would
sidewalk.
agree that paragraph 29 could also be construed as to what we're really talking about. In other words, the statutory obligations and requirements that the tenant has to fulfill are specified in paragraph 29.
No, Your Honor, I would disagree with you that the statutory items are in paragraph 29. 29 doesn't reference statutory. It says all repairs. To interpret all repairs, you have to also look at, you can't only look at one part of the policy, I would argue. You also look at the record on page 94, where paragraph 2 says you're responsible for all statutory. That's the only place where the statutory obligation for a sidewalk is referenced. And the statutory obligation, it specifically says, or connected to the premises. Connected to the premises could only mean a sidewalk, right? A statutory obligation for a portion that's connected to the premises is addressed in 94. There's nothing about statutory in 29. All 29 says you're going to do everything. And that's implicit in renting out a vacant land where they're going to be parking cars. Look, this landlord doesn't retain any responsibility at all. He's giving them the whole premises, and they're going to be in charge, responsible for everything, including the statutory liability.
Okay, we're
Thank
going
you,
to
Your
hear from some of the other parties. You'll have an opportunity to come back and respond. The next party is GMH, correct? And you are the
Respondent appellant.
yes, the second tenant, right? I mean,
Yes.
you got it assigned. You got the assignment from FDD. Is that correct?
That is correct.
Okay, excellent. You may begin.
Thank you. May it please the court, Christy Kunzig on behalf of GMH. The lower court properly denied Hunt's motion for summary judgment because as a tenant, GMH was not obligated to repair the public sidewalk. It was not part of the premises that was leased to them. And secondly, because GMH did not entirely displace Hunt's duty to maintain the sidewalk. Going first toward their claims for contractual indemnification, as this court has already pointed out today, the lease narrowly defined the premises that was leased to GMH as the vacant lot. It did not extend to the public sidewalk. And paragraph 29 of the lease deals with their duty to perform repairs specifically to the leased premises, again, not the public sidewalk. As far as common law indemnification is concerned, as a tenant, GMH was not legally responsible for any structural repairs to the sidewalk. There was no statutory duty for them to perform the repairs, and GMH neither caused nor created the condition that is
Could you do me a
apparent.
favor, talk a little bit slower?
I'm sorry,
I mean,
yes.
With the mask, and you're talking fast, it's a little hard, okay?
No
Thank you.
problem.
I have a simple question.
Sure.
Counsel, do we know at this point in time whether GMH was responsible for creating the sidewalk condition? Can we really decide that?
Yes, we have the affidavit from Mr. Mann, who owns GMH, where he said he didn't hire anyone to perform any repairs. He didn't perform any repairs. He did nothing to create or make a special use out of the area. So that suffices to prove that he did not do anything to create it. There's no need for him to go to deposition. It's not premature between the lease and his affidavit. We know what his responsibilities were, and we know that he did not create the condition. Next, as far as the Hunt's duty to maintain the sidewalk, the lease was not so comprehensive and exclusive as to displace Hunt's duty. The lease did not make GMH at all responsible for any structural repairs, and through the lease, Hunt's dictated how the land could be used. For those reasons, Hunt's motion was properly denied, and unless there are any questions, I'll move on to my portion of the appeal. Thank you. GMH did not owe a duty toward the plaintiff. As I said before, GMH did not create or cause the condition to occur and did not displace Hunt's duty to maintain it. And once again, the motion was not premature. It was supported by the lease writer, plaintiff's deposition as to how the accident occurred, and Mr. Mann's unrefuted affidavit.
Did the lease from FDD to you, did you take over all the responsibilities under that lease? Was that part of the lease with FDD?
Yes, part of the assignment, yes.
So you're saying you had no responsibilities at all for taking care of this sidewalk?
There are no responsibilities for taking care of the sidewalk. Again, the portion of the lease as paragraph 29 for performing repairs is limited specifically to the leased premises, which the lease defines at the very beginning of the lease as just the vacant lot. It does not extend to the public sidewalks abutting the lot. Back to our motion for summary judgment. As far as the court's ruling that the motion was premature, it was not premature. The unrefuted evidence with Mr. Mann's affidavit establishes that Hunt retained responsibility for the structural maintenance of the sidewalk and that GMH never performed any repairs thereto. Additionally, the cross claims from FDD and New York City should have been dismissed as against GMH. As abandoned, they were never opposed. And if there are no further questions, thank you.
Okay. So now we're going to hear from FDD, correct, as respondent as to both of these motions.
Good morning, Your Honors. May it please the court. My name is Ronnie Robbins-Kravitz, and I am the attorney for FDD, the respondent.
Counsel, as to the assignment, was there any express language in that assignment that released FDD? Any express language?
Express language, no. Just basically the actions of the parties after the assignment are the reason why I believe that the lease acted as a release.
Is that enough, the actions, or does there need to be express language?
There does not need to be expressed. It could be implied. Like the FDD held it, GMH held itself out to be the tenant. It took full responsibility of this lease as if they had signed it in the first place. They obtained insurance.
Did the landlord have to give their consent to that, and they gave their consent to that?
Yes, pursuant to the lease, the landlord, the only thing that the landlord needed to be done regarding an assignment is permission. The landlord did give permission. And they consented to it, and they accepted GMH in place of FDD as a tenant. As far as the action.
So the court dismissed you completely from the case?
Yes, Your Honor. And I agree with that.
I would think you would.
Further, the lease itself does not provide that the original tenant should remain responsible for the property, notwithstanding its transfer to GMH, when many leases do have this part in there
So there was nothing retained to you at all?
Absolutely, exactly. That's my argument.
Okay, well, we'll see if anybody can point to us anything in the record that shows that, in fact, you do have any continued responsibility. I just want to ask that before you assign the lease, Is it your position that you had any responsibilities for this sidewalk, to do anything to
No,
remove?
no, Your Honor, just as we're talking.
To clean it, to remove anything, or the landlord pursuant to paragraph 29 was responsible for?
Exactly, just paragraph 29. There's nothing specifically written in the lease that says that the tenant has to do any structural repairs. And as the photograph showed, the plaintiff had fallen on a cracked sidewalk. That's a structural repair. That was not a part of the responsibility of the tenant. And unless you have any further questions,
Okay, thank you.
Thank you.
Thank you very much. Sure. Okay, we gave you 2 minutes
Yes.
to respond to anything. So where is it in the lease that the tenants have any responsibility, either one of them had any responsibility under the terms of this particular lease?
Let me again point you to the record, page 94. There's a paragraph 2 in the lease, which I'll read it if you'll indulge me. The tenant shall properly execute and comply with all statutes, ordinance, rules, orders, regulations, requirements of federal, state, local, or any and all departments and bureaus applicable to the premises for the correction, prevention, abatement, and nuisance of any grievance in or connected with the premises during said term. That is the provision that talks about the statutory responsibility to maintain a sidewalk.
But the lease in paragraph 29 specifically says that you, the, agree to be responsible. Isn't that true?
No, in paragraph 29 it says tenant will repair everything on the premises, everything having to do with the premises. Doesn't mention statutory liability. That's why, again, I'm sorry to sound like a broken record. You can't separate and read out of the lease the other provision that specifically talks about the ordinance. And when we're talking about sidewalk liability, we're talking about the statutory liability created that even though you don't own a sidewalk, property owner, you have to maintain the sidewalk because it's any property that's connected, sidewalks that are connected to your property, which is exactly what paragraph 2, which is on the record, page 94,
But the
addresses.
thing is, isn't that a non-delegable duty that you have as the landlord? I mean, you can't say.
I'm not delegating it. I'm holding them responsible for it. The case law that talks about non-delegable says you can't say to plaintiff, I'm not liable to you. I'm not saying that. I'm not saying plaintiff, I delegated that, I'm not responsible. What I am saying, and the case law that talks about non-delegable duty says, however, a property owner can seek recourse against tenants based on a contractual provision that they're responsible. Again, 29 talks about all repairs, is very general.
Right.
But when we talk about statutory liability, you got to look at the record on 94, and you can't erase it from the lease. I think it's wrong for the court to have let both FDD and GMH out because GMH can't say by omission they were released. If they were to be released, you need a document that says you're released. They signed a lease. It's a statutory and common law in New York that a property owner can't deny assignment of a premises. Reasonable assignment, a property owner has to acknowledge and allow any tenant in a commercial space to assign to somebody else. But that doesn't mean the tenant who brings in another tenant and the landlord says, yes, you can have that other tenant do the obligations and pay the rent, is released. That would create a whole area of law in which tenants then run away, give to somebody else who doesn't abide by their responsibility, and without a specific release, they're released merely by a statutory or common law assignment, which a property owner can never deny in a commercial space. That's putting it backwards. If there's no release, FDD should not be out of this case.
Okay.
Thank you very much, Your Honor.
Yes, thank you. And we'll hear from GMH. You have 2 minutes to respond.
Thank you. Just to address the statutory duty, again, the statutory duty is for the owner of the premises, and case law is clear that where the lease does not unambiguously require the tenant to perform structural repairs to the public sidewalk, such a duty cannot be read in. That's the exact argument that's being made here. And I do want to just have one correction. GMH has not been let out of the case. Our motion was denied as premature. So I just wanted to clarify that. If there are no other questions, I will rest on my brief.
Okay,
Thank you.
thank you. The next case for argument is New Hampshire Insurance versus MF Global. I guess maybe it's good afternoon at this point, 12 noon.
Well, if it is afternoon, then good afternoon, Justice Kapnick, and may it please the court. Caitlin Halligan for the insurers. When MF Global's automated trade limits malfunctioned and one of its brokers placed 17,000 trades in a single day, the company had to cover the $141 million shortfall. MF Global wants its insurers to pick up that hefty tab, so it works very hard to persuade this court that the insurers are completely precluded by law of the case from even litigating two exclusions to coverage, one for computer programming errors and another for liability assumed under a contract or agreement.
How do you get around our finding in the previous appeal that this was a direct financial loss?
So, Your Honor, the law of the case argument that my adversary is advancing here is completely impossible to square with black-letter law. As this court held just a couple of months ago in Part 60 RMBS litigation, the specific issue for which law of the case is invoked has to be not only raised but resolved. And this court only resolved two questions in its decision in 2013. It decided that there was not sufficient evidence to grant summary judgment on the status of the trader
Right.
here, Mr. Dooley. That's not relevant
Right.
to this argument. And it also decided that the payment qualified as a loss, which the bond defines as a direct financial loss. And what the court held is that Mr. Dooley's frenzied trading was a cause, a direct cause, yes, but a cause of the payment. Now, this court knows.
But I mean, the court reading specifically from that decision, the motion, our court found that the motion court properly concluded that MF Global's loss constituted a direct financial loss.
It doesn't. We are not taking issue with that, Your Honor. But here's what we are saying. Any event, and this is common sense, but the case law also makes it very clear, including from the Court of Appeals, can have more than one cause. And that is exactly what happened here. And the exclusions set forth other causes. There can be no question from the evidence, including from MF Global's statements to its own investors, that if the computer programming error had not been made, that these trades would not have happened. And so
Counsel,
the
wasn't
point
that
is,
argument, I'm sorry to interrupt you, wasn't that argument made by St. Paul, one of the excess insurers, on the initial appeal?
it was, Your Honor, but this court has been very clear that whether an argument was raised does not dispose of law of the case. It has to be resolved. And this court did not look at all at the raft of evidence which we set
But by indicating that there was a direct loss in the 2013 decision, isn't that in effect saying that it is not an indirect loss, especially as Justice Moulton points out, the error in design was raised by one of the parties on that appeal?
So, Your Honor, two responses, if I can. First of all, we are not contesting the ruling that one of the direct causes here was Mr. Dooley's trades. And what we had argued back in 2013 was that the payment was an indirect payment, not a direct payment, which means that it would not have been a direct financial loss. We lost that question. This court decided that. This court did not examine at all the other causes of the error. And if I can just read, Your Honor, from what MF Global told its own investors, when it told its investors that there were other causes, MF Global said that the trades would not have occurred if the trading limit control on the order entry system had been correctly configured. That's at 997. That is a statement that the computer programming error caused these trades to be able to take place. And so the position that they're taking is especially radical because, first of all, they're asking this court to assume, completely counterfactual and illogical, that this event and any event could have only one cause, not multiple
But even
causes.
even if we say that.
Yes.
Exclusions are supposed to be construed very narrowly.
Yes, they are, Your
aren't
Honor.
they?
Yes.
So if we've already found that there's a direct financial loss, and these particular exclusions that they're talking about,
Yes.
in 3.9, I think that's
Yes, Your Honor.
of the bond, if those are the exclusions we're talking about, we have to construe those very narrowly, and those you say would only be if it was not a direct loss. I don't see how that was all combined. You got to help me out with that.
Yes, and I'm glad you asked that question, Your Honor. So what MF Global is doing here is that they're saying, okay, this court found a necessary condition for coverage, which that there is a direct financial loss, because that's the way the bond defines loss. And what MF Global has done is taken a snippet of the reasoning in that specific determination, which was, and we do not contest before this court, that the trades were a direct and proximate cause, and it has said that means that this court also decided that there were no other causes. What that would mean, Your Honor, and I'm glad you asked about the way to construe exclusions, what that would mean is that once the threshold question, which you have to ask in any coverage dispute, of whether there is a loss has been answered, that it would write out...
That would be the end of the story.
And that can't be right, because the parties bargained for these exclusions. And so what MF Global is saying is that every time there is a loss, because a loss is defined as a direct financial loss, that therefore none of these exclusions can apply. And that would completely upset settled expectations. Every party to an insurance contract, and especially a fidelity bond, which this is, which guards against employee misconduct, lays out these exclusions very carefully. And so simply because one of the exclusions is labeled indirect loss in the title, which, by the way, the bond itself says doesn't have any probative meaning, if that word is enough to write all of those exclusions out of the bond, then the insurers are on the hook for way more risk than either party bargained for. The last point I would add on the causation...
So here's I don't know if this is a dumb question, but I mean, so even if there's a direct loss, if any exclusion applies, that knocks out your entire obligation to pay?
That's right, and the reason why, Your Honor, is that the way the inquiry goes is you ask first, is there a loss? And that was what came to this court in 2013. And the court said, yes, there's a loss.
It's a direct loss.
It's a direct loss, and we're not quarreling with that. But then you turn to the exclusions, and there's a number of them. So, for example, nuclear malfunctions are one of them, right? And one of them is a computer programming error, and another is a liability assumed pursuant to agreement. So, Your Honor, if in answering that threshold question, which is always the first question to ask and answer, you say the answer to that, yes, there is loss, that threshold question means the exclusions are totally off the board, then you are basically telling insurers that they cannot take advantage of any exclusions which the parties write into a bond. And what that also means is that no matter how strong the evidence, and I see my time is up, if I could just finish this point, Your Honor. No matter how strong the evidence is, and the evidence here that the senior management, up to senior management, knew about this fellow's trades, but they were getting commissions, so they allowed them to continue. No matter how strong that evidence is, that if what will end up happening is that MF Global has to pay a huge sum of money when those trades come up short, that those exclusions and the mistake that they made with their computer programming, that is on the insurer's tab as opposed to on their tab. And the exclusion is written into the bond to incentivize the insured to make sure that those errors don't happen. Thank you, Your Honor.
Thank you, Ms. Halligan. You'll have a few minutes to respond. Thank you.
Good morning, Your Honors. May it please the Court, Therese Darty on behalf of MF Global.
So let me ask you something. So we all agree that when you were here in 2013, we found that that there was a direct financial loss. So now we're saying, oh, and now what they're saying is, okay, now that's very nice, but now we go to the exclusions, and notwithstanding the direct loss finding, the exclusions can still be considered because there can be more than one reason that this happened. And the exclusions are number 3 in the bond, 227 to 229 or so of the record. And under 3.9, it says indirect loss, and that's where underneath that is the losses that they're asking us, the exclusions they're asking us to look at. But those are for indirect losses, so I don't get how those square with each other.
Well, let's go look back. What the court did in 2013 was absolutely decide whether there was a direct financial loss. In arguing and looking at whether there was a direct financial loss within the meaning of the provision, the court necessarily looked to the nature and the cause of that loss. They were inextricably intertwined. If you take a look at the contractual liability provision, for example, they argued exactly the loss is indirect because it arose out of a liability to a third party. Quote, the MF Global's loss arose from its contractually assumed liability. When they looked at the, whether it was
Where were you
direct
just
or...
quoting from?
Oh, I was quoting from their briefs.
Oh, okay.
That's on the record 2330 and 2470.
Those were their briefs from the last.
The prior appeal, that's correct. What they did to argue that it was not a direct loss of MF Global, that it was a third-party loss, they argued about the cause of that loss. And this court, they argued that it was a contractual liability, which is excluded. They argued one insurer fully briefed the error in programming and error in design under 3.94. And this court litigated and determined the nature and cause of the loss. It resolved on the merits. You can absolutely have a direct financial loss under the bond, which is caused by a covered act, or you can have a direct financial loss which is covered by an excluded act. It's not true that just because you have a direct financial loss, our argument is that no exclusions can ever apply. They can apply. When do they apply? This court in the Molly Corp case very clearly made clear that when there are two causes to a direct financial loss or a loss that's covered, one that is covered and one that's not, the actual relevant question is to establish the proximate cause. The Molly Corp case, this court said, the relevant inquiry is to determine which is the dominant and efficient cause of the loss. The case that they cite of Throgsneck is the same thing. This court definitively answered that question. They said that the direct cause of that loss, the direct, immediate, and proximate, was Dooley's wrongful conduct, his criminal conduct, which resulted in the $141 million loss. Not even the insurers argue that the failure to turn on a position limit control, which is what they say is a so-called error here, was the proximate cause or the direct and efficient cause.
Well, so Ms. Haugen said there can be more than one proximate cause, which we know there can be of situations. So do we get to that?
You don't get to that because they concede that the so-called error in programming was not the efficient, direct, or proximate cause of the loss.
I'm not sure they concede that, but I mean, obviously that's your position.
They do concede that because they argue that they're not contesting this court's finding on what was the proximate cause. The failure, let's look go back to the causation, they want to argue a but-for causation here because they know that the failure to turn on a control did not cause any loss. It didn't cause a trade. It didn't cause Dooley to execute trades. Dooley's criminal conduct in executing those trades caused the loss. It put in motion everything which resulted in the 17,000 contracts, which he liquidated, and it resulted in the $141 million loss. The so-called error is they did not turn on a program. A failure to turn on a program is what they're saying is the error. That did not put into motion anything. It just failed to prevent the loss. In the absence of Dooley's criminal conduct, we wouldn't be here. The failure to turn on a control would not have triggered a loss. It would not have triggered a trade. In the absence of his criminal conduct, there would be no loss.
Counsel,
It's a matter of yes.
should we talk about Dooley's status and how it affects your counterclaim and whether you're entitled on your cross appeal to have your counterclaim granted?
Yes, it's an excellent question, Your Honor, and that's our cross-claim. His conduct, he pleaded guilty. He admitted that he engaged in wrongful, fraudulent conduct. He admitted that he committed wire fraud, the violation of wire fraud where he intended...
I know he did many very bad things. The question is he an employee or any other person?
Oh, that is not the question for here. For here, the insurers absolutely concede that under the plain meaning of 2.2 in the bond, if somebody is an independent broker, they're not an employee, therefore they necessarily are any other person.
And they argued that below, correct?
Yes, they've taken that position since 2009. They've obtained relief in this court and in the court below. They cannot now change their mind and change their position and force MF Global to prove the opposite, to prove that they are wrong. They are bound by their position that he's any other person.
Why can't they argue in the alternative on that question?
They've never argued in the alternative. They've always taken the position that he's not an employee.
Did they get a favorable ruling at any time based on the argument that he's any other person?
They have, Your Honor. They back in 2013, this court reversed the finding that Dooley was an employee in their favor, remanded, and the court below also denied summary judgment on that issue. They're bound by their position that he's any other person. With the court's malicious conduct, malicious act finding, the court should have interpreted those provisions in accordance with their plain meaning and granted summary judgment in favor of MF Global on that issue. And our cross appeal should be granted in that respect. The other thing that I would just argue quickly, if we go back to the causation under the, they argue there's a but-for. There's no but-for. But-for is not within the plain meaning of arising from, based upon, or attributed to. It actually requires a direct causal link under the case law. They cite no case which applies a but-for causation between a loss and an exclusion. And all of their cases that they cite, they are the direct cause of the loss is the excluded activity, which here, there is no causal link between a failure to turn on a position limit control and the loss that resulted from Dooley's criminal trading spree, which resulted in the $141 million loss.
Okay, you'll have a few minutes for rebuttal. Thank you.
Thank you.
Ms. Halligan, sort of following up on something she just said there. The but-for argument, I mean, I know there are certain types of cases, legal malpractice, but-for is the standard. Where do we get the but-for standard in this case?
Thank you for that question. You get the but-for standard here from the language that is the bond. As we explain in our brief, the language in the bond arising out of, based upon, and attributable to, which is different than the language in the policies that my adversary is referring to, Molly Corp and other cases. The courts have been very clear. We cite a number of cases. Mount Vernon is one of them. that where policies use that language, that but-for causation is the appropriate standard. And that just confirms why the 2013 decision cannot be law of the case. That was a question about whether there was one event that was a proximate cause. And I want to correct the record. My adversary said that I conceded that Mr. Dooley's trades were the proximate cause. I definitely have not conceded that point. What I have said is that we are not taking issue here today with your 2013 decision. What we are saying is that the finding that it was a proximate cause does not mean that it was the only proximate cause. And in light of the evidence, and don't take my word for it, look at what they told their own investors and in their proof of loss statement. Very clear, and I asked the court to look at the cites in our brief, that they said themselves that the computer programming error was a cause of these trades. So it's factually wrong and the legal standard is wrong. I want to touch briefly on two other points if I can.
Will one of those points be Mr. Dooley's status?
Yes, Your Honor.
So what, I mean, I'm not sure when you all talk about how the other side concedes, if in fact you did, but what is your position today?
So Your Honor, and if I just may,
No, please,
finish.
yes, of course.
I want to turn to that. Let me also just briefly say, if I can, we also asked the court to reverse the finding on mitigation. The evidence, and it's cited in our brief, that MF Global had clear knowledge of these trades and that they were unauthorized, there's a chart of them in the record, is very clear. So we ask you to reverse on that. Turning to the question of Mr. Dooley's status, I mean, Your Honor, this is total gamesmanship. What happened here in 2013 is that this court said there is a question of fact as to whether Mr. Dooley is an employee. And that went back, and what Supreme Court said in 2020, the decision on appeal here, is that there is still a question of fact. Now, my adversary has argued all along, including up to and in front of this court today, that they do not concede that Mr. Dooley is any other person. They are still taking the position that he is an employee. But they are saying,
have you taken the position consistently over the years that he is in fact any other person? Is that the position you've been arguing?
we have said, we said to the trial court, first of all, that we agreed it was a question of fact. And we think that when that evidence comes out, it will likely show that he is any other person. But as the trial court found, there are disputed questions about the extent of supervision. And also, one question that has not been explored is what the facts about him being an independent broker may mean for his status. And so what we're asking this court to do is to follow the trial court's guidance on that specific point, allow there to be a trial on that question, to reverse the decision of law on the case on the exclusions, which is completely inconsistent with the way this court has instructed that it be applied, and to reverse the grant of summary judgment as well on mitigation, as well as the findings on wrongful or malicious act. If the court has no other questions, thank you very much.
Thank you very much.
Let's start with your question, Justice Kapnick, on the but-for. The law is very clear that the Mount Vernon case that they cite, that's not a first-party loss case, it's a liability case. The Court of Appeals in Mount Vernon denied coverage on a provision which excluded losses, quote, based on assault and battery, where the court found that the, quote, the operative act giving rise to the recovery is the assault. That is a direct causal link. The operative act. The New Hampshire case that they also cite, this court ruled, quote, the immediate and efficient cause of the injury was the automobile, the use of which was the excluded activity. Again, in every single case they cite, the excluded risk was the operative act or the producing agent of the injury for which the coverage was sought. There's not a single case that they cite where the terms arising out of, based upon, or attributable to applied where the excluded risk was not the actual cause or the producing agent of the loss. Here, again, the failure to turn on a position limit control did not put into action any causal effect to that loss. It didn't produce the trades, it didn't produce the loss. It was just simply a passive condition that existed that did not prevent the loss. It had nothing to do with causing the loss. You also mentioned, Justice Kapnick, that the exclusion should be interpreted narrowly. That's absolutely correct. And when there are two competing interpretations of an exclusion, the court must adopt the more narrow that results in coverage. Here, they cannot put forward they can't sustain their burden. They do not put forward an interpretation of that exclusion, which includes the failure to turn on a position limit control as an error in design or an error in programming. So therefore, the exclusion must be interpreted narrowly in favor of coverage and must be denied. The only other thing that I would answer, if I may, with respect to the status issue, this is not gamesmanship. MF Global has taken the position since 2009, for 13 years, alternatively, that there's two covering provisions. It said that he's covered as an employee under Section 1, Romanet 1, and he's covered as any other person under Section 1, Romanet 2. Unlike MF Global, the insurers have always taken the position that he's any other person and not an employee. Here, they've obtained judicial relief on that position. There's no reason on the record now to force MF Global to disprove their position. It's their bond. They agree that he's any other person. He certainly engaged in malicious conduct, so judgment should be entered as a matter of law. And this 2009 case should be over. Thank you.
Okay, I wanted to thank you both for the argument, very helpful. I appreciated it. I think we all did. Have a good afternoon. Thank you both. The next case is the M. Children case, and you're the only one here, so we will give you a few minutes to, you're the appellant, correct?
Yes,
Okay.
that's correct.
Go right ahead.
Good afternoon. May it please the court, Carmen Tejas for Appellate Yoshiko M. The suspended judgment in Yoshiko's case worked exactly as the suspended judgment is intended to. Yoshiko used the additional time offered by the suspended judgment to strengthen her bond with her child through consistent and safe unsupervised visits, to progress in her services and advance towards reunification.
Counsel, was her actions immediate, or was there some sort of a delay?
I'm sorry, what was?
Were her actions immediate, or was there some sort of delay in her taking the steps to?
Your Honor, I believe that you might be addressing the period of January to May, or January to April 2020, when there was a lapse in Yoshiko's attendance in the individual counseling. That was because the suspended judgment order required that that the agency approve Yoshiko's individual counseling provider. And the agency indicated at the January permanency hearing that it no longer approved of the provider she was seeing, not because of any substantive concerns about the services, but rather because they were having trouble communicating with that provider. And so at that point, the agency then referred Yoshiko to JBFCS, where she then attended, and meaning that the agency caused this interruption in her services between January and April. And that undercuts the agency's arguments that any missed appointments in April amount to exceptional circumstances because the agency created this circumstance where there was this interruption. And furthermore, and I think very importantly, throughout the entire pendency of the suspended judgment, Yoshiko continued to have unsupervised, safe visits with her child, and the agency never raised any concerns about those visits. And that, I think, is a very important point, that where the agency comes up short on their argument that there are exceptional circumstances, is that there were never any concerns about Yoshiko's behavior. There were never any, the visits continued as unsupervised and so on, and that just goes to show that Yoshiko was in compliance with the terms of the suspended judgment, and there was nothing further to render any of these circumstances exceptional and justify the extension. And in fact, the only case cited by any of the parties that deals with this particular set of circumstance where a parent has complied with the terms of the suspended judgment and the agency seeks the extension is the case cited in our brief, Adam E., where the court finds that to extend the suspended judgment would amount to changing the terms of the agreement and would, without any notice or negotiation by the parent, and would amount to a violation of that parent's due process. And we submit that it is the same circumstances here, and that Yoshiko deserves the finality of the suspended judgment's end, where there were no exceptional circumstances and she complied with the terms.
Okay. Thank you very much.
Thank you.
Have a good afternoon. The next case for argument is Wu versus 34 17th Street.
Good morning. May it please the court. My name is Cheryl Fuchs for
It's definitely afternoon by now, so you can definitely get to afternoon now.
Okay. Well, my name is Cheryl Fuchs for defendant appellant.
Okay.
Plaintiff lost his balance and fell from a ladder. According to plaintiff's foreman, he was instructed to patch a portion of the ceiling that was 2 feet away from the garbage chute. Plaintiff says that he was told to patch an area in the garbage chute. If plaintiff's foreman's version is correct, then plaintiff was the sole proximate cause of his accident for placing the ladder where he did, which required him to lean over.
You make it seem like 2 feet is like 200 feet. I mean, 2 feet is very close to where he was, and he was given a ladder, he was drilling something into a ceiling that was about 9 feet up. He was drilling something in, and the ladder, wobbled, or the problem was with the reverberations from the drill, and he fell off the ladder. Workers are supposed to get ladders or equipment that protects them from the work that they're doing, which obviously did not happen here.
Well, the reason why he had to, we dispute that the ladder.
He wasn't in the chute. I mean, there was no testimony that it was put in the chute, and as I said, making it seem like 2 feet is like this enormous distance away. I mean, I looked at the area to the best I could figure out those pictures. I mean, it's all, it's a work area, messy.
Right, but he wouldn't have, the reason why he fell off is because he was leaning, and he wouldn't have had to lean if he put it over 2 feet.
You know what, I mean, he wouldn't have to lean if you gave him something to protect him, because he's got to drill up on the ceiling.
Well, he also said that he would not have fallen had the barricades been in place, and that's undisputed by the OSHA photographs right after the accident, that all 3 barricades were in place. So the lower court's finding that the placement of the barriers around the chute is of no moment is direct conflict with plaintiff's testimony.
Counsel, isn't the whole issue the very simple fact that the ladder was unsecured? I mean, if you look at Nieto, if you look at Cáceres, you look at Ward, those are 3 cases, three appeals that came through the first department that all said that the issue was that the ladder was unsecured. Here, there's no protective equipment. Here, there's nobody spotting the worker on the ladder. There's nothing. And my colleague brings up a very valid point. 2 feet equals 24 inches. And I'm using my hands to approximate, but it's not very far away.
I see that my time is up. I just want to know if
You
I
can
could
just answer that question.
Yeah, okay, thank you. In the other cases, the plaintiff testified that there was a second person that was required to secure the ladder, and here the plaintiff testified that he didn't require anyone else and that he specifically tested the ladder and it was secure.
Okay, you'll have a minute for rebuttal, so let's hear what plaintiff has to say.
Good afternoon, Your Honors. On behalf of the respondent, I'm Douglas Hoffer. Contrary to the assertions of appellant, the lower court properly granted summary judgment to this plaintiff under Labor Law 240, subsection 1. By granting summary judgment, the lower court didn't break any new ground. It didn't expand our jurisprudence in any way whatsoever. The lower court simply took uncontroverted facts that we all agree upon, applied this court's long, clear, and extensive, factually similar circumstances, and decided that this particular plaintiff was entitled to the extraordinary protections of the labor law under 241. This appeal actually begs the question if this catastrophically injured plaintiff who fell 5 stories and was impaled by 4 steel rods is not entitled to these protections, then I suggest to this court that no one is. Let's talk about the uncontroverted facts. This plaintiff was on a ladder drilling screws into a ceiling when he said the vibration and pressure he was applying caused him to lose his balance. We agree. We agree that he was working over a garbage chute at the time that he lost his balance. We can agree that other than that ladder, he wasn't provided with any fall protection equipment, contrary to the defendant's own internal regulations, rules, policies, procedures, and the very documents they generated saying that protections were provided. And also, we can agree that he was doing this work in the presence of and at the direction of his supervisor. His supervisor, who then 3.5 years later said, well, yeah, I was his supervisor, I could see him, and he was in 2 feet away from where he should have been. Now, the lower court found that this is a classic example of a case where a worker was not provided with adequate fall protections. And that's obvious, because had he been provided with adequate fall protections, he wouldn't have fallen from his ladder, and then separately and independently would not have fallen 5 stories. The application of the gravity of the 5-story fall caused massive injuries, including brain injuries, fractures, open fractures, surgeries, and has left him disabled. So the defense is that this person, by moving his ladder 2 feet away, an argument I would suggest is a feigned issue that first came up 3.5 years after the accident, and only in the course of this motion practice, that is a feigned issue, but that even if we were to accept that, it is this court's clear, consistent findings in multiple cases, including the Caceres and the McGee case, that negligence, contributory or comparative fault is not a defense to the labor law, section 240, subsection 1. And I'll read from Caceres. Their arguments that plaintiff caused his own injuries by allegedly placing himself in a position where he had to lean and reach at most establish comparative fault, which is not a defense to labor law 240, subsection 1. I urge this court to affirm the reasonable, fair, and correct decision of the lower court to grant summary judgment pursuant to labor law 240, subsection 1. Thank you.
Thank you, counsel.
If I could just briefly address the lost wages issue. Plaintiff testified that he was paid in cash, received no W-2s, and would demand tax returns or authorizations, which plaintiffs refused to provide. The lower court said that while plaintiff's testimony alone is not evidence here, nothing, the defendants failed to provide affirmative evidence of a lack of lost earnings. How could we prove the negative?
Well, look, I mean, it's possible at trial they may be able to come up with something that they were not able to come up with at the deposition or here. you know, it's probably not their biggest claim or their best claim. But don't they at least have an opportunity to present that to you at trial? If they don't have it, they won't be able to present it.
They filed a note of issue certifying discovery is complete. They can't just come up with new things. They refuse to provide tax returns. They can't have it both ways and suddenly produce them. The only thing the court said that they could try to do is rely on workers' comp records, which my client was not a party to those hearings and cannot be bound by those findings. So that claim, at the very least, should be dismissed.
Okay, we'll take a look at it all. Thank you very much. No, I'm sorry, you don't have a cross appeal, and we have a long time still of arguments. Thank you. Okay, the next case for argument is People versus Orozco.
Good afternoon. My name is Ben Hoynes. I'm a law student intern with the Office of the Appellate Defender, representing Eric Orozco. The prosecution's case against Mr. Orozco centered on 1 second of dark, grainy surveillance camera video. But instead of letting the jury decide for themselves what they saw in that 1 second of video, the prosecution overwhelmed the jury with the testimony of multiple law enforcement officials who interpreted the video for the jury and told them what they should believe. Perhaps most egregiously, Mr. Orozco's federal probation officer was permitted to testify that after he reviewed the surveillance camera video, he believed there was sufficient evidence to revoke Mr. Orozco's federal probation and sought a warrant to detain him.
Counsel, would Mr. Orozco's federal probation officer be in a position to identify him in that video? I mean, he's had contact with him, he knows what he looks like.
Yes, so Mr. Orozco's probation officer did in fact identify him in the video, and that identification was improper. There was no reason to believe that he was better positioned than the jury to make that identification.
He knew who he was. I mean, he's his probation officer. They've had
Certainly.
close contact with each other.
But this court has made clear in the Coleman case that familiarity alone does not justify making that identification on the video. In Coleman, it was...
Well, counsel, it's more than familiarity here, right? Because allowing the officer to testify, it was an aid to the jury because, as you just stated, the video was grainy. So doesn't that justify allowing the officer to...
So the moment in which Mr. Orozco allegedly fired a gun into the air was certainly dark and grainy, but there were other moments on the video, Your Honor, indoors in which the person they contended was Mr. Orozco, in which the video was relatively clear. Mr. Orozco was in front of the jury. There were also...
Well, the gravamen here is the point where he fired the gun, right? I mean, that's what the whole case is about.
Sorry, could you repeat the question, Your
The
Honor?
gravamen here is the point where he fired the gun, right? So that's the point where the jury has to make the identification, not at any other point in the video. Isn't that right?
Certainly, in the prosecution contended that Officer Nicholson, who was the probation officer, made the identification in separate moments that were not the immediate moment in which the gun was fired. The prosecution contended that you could follow him to other locations, and that was where the identification was made, not in that exact moment. The camera was positioned across the street, and it was nearly impossible to view who it was.
But counsel, the more you say nearly impossible, the more the layperson identification, lay witness identification falls within the construct of People v. Rivera, doesn't it? Where there has to be some basis for concluding that the witness is more likely to correctly identify the person than the jury. The background, the familiarity, the long-standing familiarity between the probation officer and the defendant surely would be of aid here, of assistance here, as my colleagues have been pointing out.
So, Your Honor, even if the identification was proper, which we contest, it was still error for the probation officer to then go on and say, in his opinion, after he watched the surveillance camera video, he, quote, saw enough to take action. That was his opinion about the video, the very same evidence that the jury was tasked with analyzing that revealed that he, as a federal law enforcement official, had already found Mr. Orozco guilty of the crime. The testimony also was indicative of a broader issue in this case, which is that Mr. Orozco's federal probation came up numerous times at trial.
Counsel, given the totality of the evidence, was that the subject, was that statement by the probation officer the subject of reversible error?
Sorry, I missed the last part.
That constitute reversible error.
Yes, Your Honor. The evidence in this case was not overwhelming.
You have building residents, you have surveillance videos, you have statements by the defendant after the Miranda warnings were read, you have recorded telephone calls, and you have a later statement to the probation officer. You have a lot of elements here that kind of add up, don't they?
Your Honor, as everyone acknowledged at trial, this was prosecuted as a circumstantial evidence case. The alleged statements that Mr. Orozco made during his interrogation and during the calls he made from Rikers Island were ambiguous. They were entirely susceptible to an interpretation that he was responding to the allegations made against him, and he was, if I may just finish this point.
Sure, absolutely.
And he was similarly saying, when he's saying, I messed up, he was referring to, he was arrested, he was incarcerated. And I'll just reiterate that the moment in which he allegedly fired a gun was dark, grainy, and blurry. And so, for all of these reasons, we request you reverse Mr. Orozco's conviction, and perhaps I can address the sentencing point on rebuttal if that's
That would be fine. You could do that then. Thank you very much.
Good afternoon, Your Honors. Samuel Goldfein for the people. I'd like to start off just by correcting the record. The detective who identified the defendant in the video identifies him in the moment he shot the gun. That's on page 295 of his testimony. So he does identify it in the moment of the video, whereas counsel just stated the video is dark and grainy. The second thing I would just highlight is that all of this mention of the probation officer is in the context of defendant confessing repeatedly and admitting his guilt in various stages. He admits it to 5 different people. And each time this evidence of the probation officer is coming in because it's interwoven with that testimony. But defendant's confessions, his admissions, are highly, highly probative in this case. And there's no possibility that that anything that counsel could have done with respect to the ineffective assistance point, or even with respect to these identifications, it's defendant. He confesses, he identifies himself in the video, he admits to the probation officer that he fired the gun. So if there are no questions about that, I would turn briefly to the excessive sentence.
Go ahead.
So I think defendant's sentence is fully justified here by his actions. He's got a loaded gun. He's firing it on the street in public. It's designed to intimidate and menace. I think my opposing counsel will get up here and talk about the co-defendant's sentence. It is a lesser sentence. He wasn't on probation at the time, and he also did not fire the gun. His sentence is for holding the gun versus defendant's sentence is for holding and firing the gun. And again, he was on probation at the time. If there are no further questions, I ask that you affirm.
Okay.
Thank you very much.
Thank you very much. All right, you have 2 minutes for rebuttal.
Thank you, Your Honor. With regard to the sentencing point, Mr. Orozco was sentenced to 12 years for criminal possession of a weapon in the second degree. No one was injured. There was no intent to injure anyone through this act. Mr. Orozco had no violent criminal history. His prior convictions were drug-related. Respondent notes that his co-defendant received a lesser sentence, but more importantly,
Well, they pled guilty, right?
yes, Your Honor.
And here the
To a lesser charge also.
Right, and here you have a defendant who's violated while he's on probation.
Sure, Your Honor, but a person who was separately involved in an incident that night, Darren Coxum, who fired a gun into the apartment building later on. This is an incident in which the prosecution conceded Mr. Orozco was not involved in. He received a sentence for attempted criminal possession of a weapon in the second degree of just 5 years. Now, his conduct was far more dangerous, far more reckless, and he had a violent prior felony conviction.
Was that a conviction after trial, or did he plead guilty? Mr. Coxum?
Mr. Coxum similarly pled guilty, yes.
So it was a bargain for sentence that he received the benefit of, as opposed to, and it was a lesser offense. I mean, this is a different circumstance here.
Yeah, and Your Honor, certainly folks can plea bargain for lower sentences, but in this case, the penalty that Mr. Roscoe received in exercising his constitutional right to go to trial should not have been a sentence of more than double what Mr. Coxum received for far more dangerous conduct. I see my time is up. Thank you very much.
All right, and Mr. Hoynes, you're still in law school?
Yes, I'm a 3L at NYU.
Okay, well, thank you very much for your very excellent argument, both sides, and we wish you the best of luck.
Thank you.
Hope to see you again here as an admitted attorney. Okay, the next case for argument is Hess versus EDR Assets.
Good afternoon, Your Honor.
Good afternoon.
For the appellants, Nativ Winiarski from the law firm of Cook & Marino, Winiarski and Bittens. So I'd like to frame the issue on this appeal the way the respondents framed the issue to the lower court below in their reply brief to the class certification. And what they said is as follows. They said this is a case concerning current and former tenants who offer deregulated leases. And they say that the landlord failed to file after Roberts in 2009, after Gersten, and didn't file till 2017. And they say the question then...
Counsel, this is a class certification motion, correct?
Correct.
Okay, we've already held that they've adequately alleged a fraudulent scheme to deregulate, correct? We held that in a previous appeal?
In the previous appeal was a motion to dismiss, which they moved for class certification, and we moved to dismiss. The court said there weren't enough facts, you have to go through discovery. And what this court said in discovery is that it affirmed the denial of the motion to dismiss, but it similarly affirmed the denial of the class certification, saying they have to make out their claims. So that's where we are today.
Don't you just only have to show that the claim is not a sham?
They have to show that there's merit to the claim, which is in fact why the court in the class certification motion began by saying, by going to the merits of the claim, and said as an initial matter, the court finds the claim asserted here meritorious. So the question is the claim meritorious? And their whole claim is predicated upon use of a default formula based upon the late registrations. And in that regard, this court previously held in AEG, and Justice Moulton, you were on that bench, and the same with Justice Gonzalez, you held that the failure to file late filings contemporaneous to HR registrations does not allow a look back past 4 years.
Did you make this argument in front of Supreme Court?
Excuse me?
Did you make this argument in front of the trial court?
The arguments as to whether default formula should be applied?
No, just whether she made out a meritorious claim.
Yes.
You made that argument below?
Yes.
Okay.
So the issue then is whether late registrations standing alone is sufficient for purposes of showing a default formula. And they need to get there because it is undisputed that there is no overcharge if you look at the standard 4-year period. In fact, if you go back to the year 2000, when this was a decontrolled apartment that was decontrolled in 2000, the first tenant came in, pays a rent of $2,000. The rent between 2000 and 2015 never changed. So this is an unusual circumstance in which the legal regulated rent would have actually been greater than the market rent once you applied, of course, the vacancy increases and the rent guideline board increases. So then the question again becomes, does the late registrations, is that sufficient for purposes of applying the default formula? And this court in AEJ, in Corcoran, following the line of reasoning in Regina, said no. So what do they do? So they say this constitutes a fraudulent scheme to deregulate. And they need to say that because late registrations alone do not warrant use of the default.
But I mean, again, I follow up on what Judge Moulton said. This is simply a motion to certify this matter as a class action. And we do not have to get into this very deep dive on the merits. Our merits inquiry on this, at this stage, is limited. I mean, maybe they won't be able to prove their case, but right now, don't we just have to look at the qualifications for class certification, say that, okay, they've made some claims here that are valid, and then go on and we'll see again a few years from now.
You still have to find out if there's merit to the claim.
Right, if there's some merit.
Right, and that's why, for example, in the Gridley decision, which we cite, in our papers. The Gridley decision from the Second Department was a pre-discovery motion in which not only did they find that there was no merit, but because of the fact that there was no merit, in seeking to apply use of the default formula simply predicated upon a late filing, they denied the class certification pre-discovery. And so here, I'm not looking to do, Your Honor, Justice Kaepernick, a deep dive. I'm simply looking to answer the legal question of whether late registration standing alone warrant use of a default
And
formula.
Gridley was a summary judgment case, and it was not a class certification motion. It was also the Second Department, which, you know, we certainly look at, are not obviously compelled to follow. And I mean, the facts there were somewhat different. I know you relied very strongly on that case.
So in Gridley, it was a pre-discovery motion. And so the court labels it as, in essence, a motion to dismiss. And it says, since we can't apply a default formula simply predicated upon a late registration, that there is no basis, therefore, to find the class certification, and denies the class certification
Counsel,
motion.
you don't want to talk about typicality and commonality. You don't want to reference any.
No, I'm simply looking as to whether the late filing.
You want us to just focus on merits.
On that issue. Because
That's it. You concede everything else.
Yes, we did.
Okay.
So just so we're clear, and it needs to be made very clear, this is not a deregulation case. This is not a case where there were rent-regulated apartments that were later decontrolled, and there was a failure to regulate. So this doesn't follow. This isn't like a Roberts or a Montera or those Casey cases. This is strictly a non-feasance case. The apartments at issue were never regulated, and so it's simply a failure to file. And in that regard, there's not a single case.
What else,
that was
do
ever
they
issued.
also allege, your opponents also allege that you didn't provide leases to any of the tenants, saying that these are rent-stabilized units? That's another indicia, isn't it? Possibly a fraud?
Well, that's only because they weren't registered as stabilized, but they were never deregulated. But the act that they're contending warrants the default formula was the failure to file.
Well, by not giving your tenants leases that said that this is a rent-stabilized apartment, that means that the tenants won't be advised of something that could concern their rights.
You're correct, and you're speaking about a failure to act. And if you look at Regina, when it gives a definition of fraud, what they talk about are affirmative acts of malfeasance. And what we're speaking here is a failure to act, which is nonfeasance, and there's a grave distinction between
Counsel,
malfeasance and
you'll
nonfeasance.
have 2 minutes to respond. Thank you.
May it please the court, Roger Sacker, Newman Ferrara for the tenants. As we explained in our brief, there's 7 things wrong with defendants' arguments here, but let's just focus on one. Let's talk about Gridley. Gridley holds that a landlord is entitled to pre-discovery summary judgment when it deregulates after Roberts, because the deregulation there took place in 2010, and then fails to re-register until 2016. First off, Gridley shouldn't even be relied on. It's a merits determination. It's a summary judgment, pre-discovery summary judgment determination. This is class certification. All we got to show, it's not a sham. Second, Gridley is a Second Department case, completely in opposite to this court's jurisprudence. Gersten required prompt re-registration in March of 2012. We know this. That's Park v. DHCR, Montera, Nolte, Casey. We've done this. The list goes on and on. Third, Gridley doesn't even save this landlord anyway. The landlord in Gridley registered in February 2016 after receipt of notification from
And in this case, it was a while before the landlord. I think you had to let him, I think that DHCR had to notify him twice, and this was also after that some of the tenants said, hey, we got notified by DHCR. They were supposed to be rent regulated. They said, nope, that's a mistake.
They said mistake. And not only that, November 2017, nearly 2 years after DHCR's letters. Now what they say, and this is in their reply brief, they go, oh, we made a mistake. Well, landlords are charged with knowing the law. DHCR says you have to register all apartments. The law, J51 law itself says you got to register all the apartments. They're claiming that a landlord can escape liability by going, oops. That's ridiculous. We ask that the court uphold the grant of class certification. Thank you.
Thank you.
We just need to understand the critical fact in this case.
So, counsel, isn't it correct that the registration occurred only after DHCR sent the owner a notice of a proposed action?
So again, there was never a deregulation,
But so what does that matter?
because what you're talking about in
I mean,
Roberts,
because they were, what they, these particular people lived in these apartments, they were given leases that said they're market rate leases, they're not regulated.
Right.
Now, then it turned out that they were supposed to give them, and once they were supposed to give them regulated leases, and once they were supposed to register, then that's when they had to register, and they had to be told a couple times before they registered.
DHCR sent out their notice in 2016. The notice in 2016 says as follows: units receiving J51 tax benefits for a residential rehabilitation must be registered.
Right.
These units, when they received the J51 certificate back in 2006, it's being reduced proportionally by virtue of the fact that 77% of your units are not even regulated. So the landlord had good reason to believe that these units were not covered by that J51 regulation. Roberts itself, the Roberts Court of Appeals says, rental units in building receiving the exemptions or abatements. In other words, the units had to receive the abatements, and if it did, you had to register it. But here, our J51 certificate specifically said, these non-regulated units are not being covered by the J51. And so then DHCR sends a notice in 2017, in April 2017, saying, you know, we're taking the position, despite the DOB notice, that you need to register this. And we put in opposition saying we understood we didn't have to because the J51 certificate specifically reduced the abatement by the percentage. So then DHCR says, no, we're telling you need to do it. Within 30 days, we complied exactly with the DHCR's order without even taking a paw. So there was no delay of a year or 5 years or 7 years. This was compliance with DHCR's order within 30 days once they made it clear that we had to comply with their directives.
Okay, thank you very much. We'll take another look at these papers. Have a good afternoon. The next case for argument is London versus London.
But McDowell.
Oh, I'm sorry, People versus McDowell, I apologize. Sorry. You'll be next. We're getting near the end. Sorry. Good afternoon.
Yes, good afternoon, Your Honors, and may it please the Court. John Vang for Patrick McDowell. I'd like to talk about the sentence in this case. Before trial, the people offered a 3.5 to 7 year sentence concurrent to cover all of the counts. And after trial, however, the court imposed a substantially greater sentence of 15 years to life on Mr. McDowell following a persistent offender adjudication. Even looking at the minimum in this case, this quadrupled his sentence. There was nothing substantial to be gained here.
Also, could you address then the relevance or the import of the defendant's violent criminal record here?
Prior. Well, I mean,
how does that weigh in inappropriately to the sentence? You have a
I'm not saying that it weighs. I'm not saying that it's.
Wait, let her finish her.
You have a first-degree manslaughter conviction for fatally shooting a woman during a robbery in '81. You have first-degree contempt for threatening to kill his wife in '99, a robbery, robbing his wife in '98, holding up a couple in the park in 2001, telling the couple he had a gun in one hand and a knife in the other. How did these priors not factor into this sentence?
Well, certainly, Judge. You know, the fact that he had those prior convictions, you know, that's what the people relied on to establish that he was eligible. And certainly he was eligible. We're not disputing that. The question, however, is, did the court imposing this persistent offender adjudication exact a trial penalty? And we know that it did here because the people, for several months before trial, offered the 3.5 to 7 year sentence, knowing full well the extent of his criminal history, knowing full well the nature of the underlying charges, but nevertheless offered this non-persistent sentence to cover all the offenses.
You're talking about a bank robbery, you're talking about, what is it? Attempted rob 2 at 2 banks and grand larceny at another bank.
It's not an attempted rob 2, it's an attempted rob 3. They're non-violent offenses.
Attempted rob 3,
These are all, and it's important to clarify, these are all non-violent offenses. They're
Wait, can one of these incidents occurred 7 months after his release for a prior case, correct?
Yes, and I think, and that is the case. However, still, the question to look at here is whether what the court ultimately did here in this case in imposing on the people's motion this persistent felony offender adjudication that quadrupled at least the minimum and certainly expanded his exposure to life qualified as a trial penalty.
Had the court made an offer to him prior to trial?
I'm sorry, I didn't hear that.
Had the court made an offer to him prior to trial, or was that just the people's offer?
The court didn't make the offer before trial. It was the people who made the offer before
So
trial.
once the trial is over, the court is in a position to adjudicate whatever sentence they feel necessary based upon the record, to protect the public, and things of that nature, correct?
But yes, and I have a couple of responses to that. First of all, the public was already protected by an existing adjudication, and true, he was released following that adjudication.
And then committed another crime.
Right, but when he goes before the parole board again, the parole board is going to have before it these new convictions, as well as the fact that he had been previously adjudicated a persistent offender. That more than sufficiently protects the public. However, there are policy considerations that I ask that the court consider here. There has been discussion among the legal community about the trial penalty and what it's doing to transform the criminal legal system. And I think the trial penalty, which I believe was exacted here based on the people's motion and the people's pre-trial conduct and their post-trial motions, this serves
Counsel,
to discourage.
You're positing that the court should basically use a formula. Whatever the people's offer is times what? Times 1, times 2, times 3?
I don't think that the court should use a formula, but I think under these circumstances, what the court did was purely symbolic. He already had a prior adjudication. Imposing a non-persistent offender adjudication in this case would, first of all, would be commensurate to the non-violent, D and E offenses in this case, but it would more than sufficiently protect the public because, when he comes forward the parole board again, and we attribute the parole board with making these determinations about public safety, the parole board will certainly not release him on the first or even the second parole appearance date. The public is already protected by an existing life sentence. Imposing an additional persistent offender sentence did nothing but to convey that we're punishing you for exercising your right to trial.
All right, you'll have a minute to respond. We'll hear from the people. Good afternoon.
May it please the court, Your Honor. My name is Patricia Curran, and I represent the people on this appeal. The court's sentence was fair and appropriate. As Justice Gonzalez has pointed out, this defendant has an extensive record, including some really horrifying violent crime.
Counsel, in light of that, why did you make the 3.5 to 7 offer?
Your Honor, the people apparently made that offer, but before the suppression hearing and trial, and at the start of the suppression hearing, made clear that once they started the trial, that offer would be withdrawn. Certainly after they now know that what evidence they can go forward with, and all of the witnesses have come in for the 3 crimes that defendant was indicted for, the court was certainly in a position to, after trial, impose a higher sentence.
Yeah, but with that in mind, presumably, although the offer was made before the hearings, presumably the people knew about his criminal history, his past.
Yes, Your Honor,
It seems that 3.5 to 7 and compared to 15 to life, there's a great difference there.
Well, Your Honor, I might remind the court that this defendant was adjudicated in 2001 as a persistent felony offender, and he had only been out of, and he was on lifetime parole, I should add, when he got out of jail and a couple of months later started this spree of crimes. Given all the history here, I think that the sentence imposed here was fair and appropriate.
That's not my question. My question is, why did you make the 3.5 to 7 offer?
Why was the offer made?
Why was that appropriate?
I don't know why the offer was made. The record doesn't show that as far as I know. I can only assume that the offer was lower at the point before the people had called all the witnesses down for the hearing and trial.
So then why isn't that a punishment for going to trial, holding the people to their burden?
Yes, and they don't know that there will be a verdict. Was that your question? I'm sorry.
No, I mean, if the offer was 3.5 to 7 prior to the people presumably bringing in all of their witnesses and all of the evidence being put forth, and now it's 15 to life when the judge sentences him, how do you not make the relation that that's because he went to trial? Because now the people had to bring in their witnesses, and they had to go put forth all of this effort. So now it's 15 to life.
Yes, Your Honor, and one of the reasons for plea bargaining is to avoid a trial, obviously, because of limited resources and things of that ilk. If there are any other questions about any of the other points in the brief, I'd be happy to answer them, or any other questions about the sentence.
Wait, I just want to make sure that I understood your response to Justice Pitt's question. Are you saying that it's okay to impose a 15 to life sentence because he exercised his right to go to trial?
I'm sorry, Your Honor, I didn't hear the last part of your...
Are you saying in your last response to Justice Pitt that it is acceptable to impose a 15 to life sentence on this defendant because he exercised his right to go to trial?
Well, Your Honor, there's no evidence of that at all. I know the defense makes that argument, but there's no evidence that the judge punished him for going to trial here whatsoever. In fact, quite the opposite. The court heard all these witnesses, heard what the defendant had been convicted of, and made its own decision as to what the defendant should be sentenced to. There is absolutely no evidence that he was punished for going to trial here.
Did the lower court ask you to put in for discretionary persistent, or was that a decision that was made by your office?
I'm sorry, Your Honor, I'm having trouble hearing you. Could you repeat it?
Did the lower court ask you to file for discretionary persistent, or was that a determination that was made by your office after trial?
I have to assume that it's a determination made by our office. We are certainly compelled to file predicate felony forms. I'm not certain that that holds true for discretionary predicate form. But given this defendant's record, I don't think that that was an abuse. I think it was appropriate. There being no further questions, we rest on our brief. Thank you.
Thank you.
My adversary argues that there's no evidence that he was punished for going to trial, but yet acknowledges that the people made very clear, if you don't accept this 3.5 to 7 year offer after trial, we are going to ask for a persistent felony offender adjudication.
Well, wait a minute. Is that correct? Is that what happened?
That's what happened. That's
Or
what
is it that they said that if you don't accept it at this time, it'll be withdrawn?
I'm sorry, that it would be...
That if you don't accept the offer at this time, that it will be withdrawn. That's
my
very
adversary
different
acknowledges, yes, that's exactly what the people said. We will be asking for a persistent felony offender adjudication after trial. Now, what happened after trial is that there was nothing that came out that substantially varied from anything that the people already knew before trial. The witnesses were all local. Sure, there is, the expense of trial that, could have been saved with the plea, but that could have been easily resolved with consecutive sentences, non-predicate sentences on each of the convictions, the nonviolent
Counsel,
convictions.
I'm just wondering then, what is really the benefit or the purpose of plea bargaining? No one's entitled to a plea bargain, right? So you get a plea bargain, either you take it or you don't, and then you go to trial, and it is what it is. But that doesn't mean that you're being punished. That just means now your exposure is different.
Yeah, but the punishment, Your Honor, refers to the disparity, the great disparity in the sentence that you get after trial. And that great disparity, I would argue, leads to a presumption that the defendant was punished as the evidence and the circumstances here revealed based on the pre and the post trial offers, as well as the people's representations.
But here, counsel, I think you just stated the defendant was made aware of that disparity. The defendant was made aware of what the people would intend to do if he did not accept the plea offer. I have to imagine that he was counseled by his attorney, and elected not to accept the plea offer, correct?
But it's true that he was made aware of that, but I would argue that, what that speaks to is the fact that this belief that a persistent offender adjudication was necessary to protect the public was, in all due respect, disingenuous. And that was fully conveyed by the fact that the prosecutor made that essential threat to the defendant. And on the people's motion, the court later on adjudicated him a persistent offender. When doing so was purely symbolic, there was already a life sentence there. The pure symbolism of it is what reflects the trial penalty in this case. And for these reasons, we ask that the court vacate the adjudication. Thank you.
Thank you. Thank you both. Okay, now the next case is London versus London. Counsels, before you start the argument, I'm not taking away from your time, but I just want to note, when I say for the record, we don't really have a record in this courtroom, except we are being, we are live on YouTube, so there's a record in that respect. We did receive a letter that Mrs. Margot London passed away during the time that the appeal was proceeding. Prior to today, obviously. This was all the lawyers apparently received a letter so that they were all aware of it, and nobody objected to this appeal being heard today because of her particular position. Her husband is still alive, and he can cover all of those things, and will be, I think, implying to be the representative of the estate. But I just want to make sure while you're all here, because we don't have that opportunity in the appellate division, that is a fact what happened, and that there was no objection to this appeal proceeding today. Is my understanding correct?
Your Honor, that is correct.
Okay.
My learned colleague had submitted, his office anyway, had submitted that letter, and we did not object.
Okay, and no one else who may have been interested. Okay, I just wanted to state that. All right, you can sit down, counsel, and you can now start your argument and introduce yourself. Thank you.
Thank you, Your Honor. My pleasure. May it please the court, my name is Michael Cutson, and I represent Sabrina Morrissey, the personal needs guardian and former property management guardian of Zachary L. In this case, Your Honors,
she's been acting in this new position for quite some time now, hasn't she? Or has she actually started in the new position?
Well, she's been continuously the personal needs guardian.
But as a result of Judge Kennedy's decision, didn't she change her role?
Her role was changed in the sense that she's no longer in charge of his property.
The property, right.
That's correct.
So, right, and she's now just continuing on.
And she's continued on as his personal needs guardian.
Right, okay.
Can I just ask one question? The property that's in question here, his assets, they are all in a trust?
That is in large measure correct, but not completely. He has
What is outside of the trust?
He has substantial personal memorabilia, art, et cetera. Also, as a result of this, as this court knows, Margot London, his mother, passed away. He's also coming into substantial wealth that's going to result as a result of certain trusts that are going to be liquidating now, and where they don't go in continuing trusts, but they continue directly for his benefit. Directly to him outright. So he's going to have additional assets that are going to have to be addressed.
Why would the continuation of a property guardian be necessary for those particular assets? I mean, the trust assets are going to be monitored by the trustee, right? And that trustee would have to find an accountant and all of that. But these other assets, why is it necessary after this 2-year property guardianship expired? Why do we need to continue it?
Well, with all due respect, Your Honor, it's necessary for both the trusts as well as for these additional assets. As far as the trusts go, someone's got to be monitoring everything for him to seek the accountings. Part of these proceedings also involve, compulsory accounting proceedings. Someone has to be looking out for him. The same is going to be true for these new assets. There's going to be a liquidation of this trust that previously had held the 64th Street property. There was a substitution in 2017 of an LLC interest into it. That's going to have to be addressed for Zachary L. There's going to have to be the continuing payment of taxes. Someone's got to do that for him and file his tax returns.
Well, she's
Someone's
not,
gotta-
she's not filing his tax returns. I mean,
That-
she was helping him accomplish a lot of this, but wasn't it the court's determination and some of the other parties' determination that there were other, that he was better, he was no longer taking these drugs that were addictive drugs?
Your Honor, that determination that he had no longer been abusing Klonopin had occurred prior to the actual guardianship being made a 2-year guardianship. That's the first thing. Second thing, the so-called improvements that he had was that he, was belied by the fact that he was so emotionally unstable, he couldn't even appear in court. He couldn't even say, I want to, as a person in need of a guardian, I continue to consent to this guardianship and I want this guardianship.
Let me ask you a question. If these assets are given to him and there becomes an issue, can a new guardianship be applied for the property, the guardian of the property? I mean, it's not that now it's taken away, it's gone forever, right?
That is correct. A new guardianship proceeding, if need be, can be commenced.
Sort of in following up with what Judge Pitt asked, I mean, it's somewhat different or somewhat unusual, I thought, to actually have such a limited time guardianship. Usually people get property guardians and they just go on and on. So this one, there must have been, why was it just done a 2-year guardianship?
My understanding, Your Honor, is that it was done as a 2-year guardianship because initially Zachary opposed the guardianship. Then but a temporary guardian, Sabrina Morrissey, who's like the golden ticket for guardianships in New York State. She's a well-known guardian, she's often a go-to person of the court system for guardians, for complex guardianships. She goes in as a temporary guardian. He eventually, forms a relationship with her, but the court had to make sure that it continued safe, that he was continuing to consent with it. He consents. That makes it a consent guardianship. He's a person in need of a guardian. And the law is clear. When you go and you see, when someone is a person in need of a guardian, then any change, to prove that there is a need for a change has to be by clear and convincing evidence by the other side. That's the law. You are correct, Your Honor. And on top of that, as we know, a guardianship case is a continuing record. Matter of Mildred O. Same index number is continually used. We've got this going here where this, it was done for his protection. He, says, you know what? In spite of the fact that, I've still got issues and problems and, severe psychiatric issues, severe health issues, this guardianship works for me. I trust Sabrina Morrissey. I want her to look over my accountings. I want her to look over my assets. I want her to insure my property, to do all the things that I can't do myself. And he asked for it, and the wrong standard was used by the court. There were no available resources that changed in her that changed.
Okay, counsel, I'll give you an extra minute or
thank
so
you.
on rebuttal. Let me hear from the other side first, okay? Thank you.
Thank you, Your Honor.
You're welcome.
If it please the court, my name is John Morgan for Allen London. And,
So, counsel, I'm going to jump into this from a different angle.
I'm sorry?
I'm going to jump into this from a different angle, from a different perspective. So we know that the court, in determining whether to appoint a property management guardian, first has to determine whether the appointment is necessary, right? And then after that comes the question of whether the person consents or whether the person is incapacitated, right? It's at least a two-step process. So with respect to the issue of necessity, the necessity of the guardianship of the, for the property, appointment of a property management guardian, I would, the conflict that I see is between the father's desire that the son function on his own 2 feet and the property management guardian's perception that basically the son has progressed so far under her appointment, but that he will most likely decompensate if she's not in the picture. And yet she is in the picture as a personal needs guardian, and the son does have the ability and the revenue to be able to appoint her to do more than. So how does this issue of necessity get resolved here in your view?
The issue of necessity, of course, is front and foremost, particularly in a case like this where the guardianship was set up for 2 years, because between the time of the petition and the time of the hearing, just a 2 or 3 month period, there had been real huge improvement that the judge herself on the record in July of 2017 noted. So it was a 2-year period with the idea then in 2 years, also given the fact he's 34 years of age, let's see how he's doing in 2 years, whether we need a guardianship to continue at that point. That 2-year period came up in July of 2019. So the issue then that was tried, started in January of 2020, was necessity, looking at available resources. And the judge, contrary to what is said in the brief of the appellant, Judge Kennedy is very familiar with trusts and how they can function to provide an available resource, obviating the need for a property guardian. And in particular, what was the problem with the prior trust, the other 2008 Grat Trust, is you had 2 other beneficiaries, including Mom, Margot London, who was a trustee. So you had 2 problems. He was not the sole beneficiary, and also you did not have an independent trustee. Independent trustee was the key. So Judge Kennedy, therefore, took the testimony of Paul Siegfried extensively, Alan London extensively, and of course Sabrina Morrissey, and determined that the 2019 trust, the new one, with Paul Siegfried as the trustee, the sole beneficiary being Zachary London, $3 million, actually more than $3 million in that trust, was an available, sufficient resource that you did not need a property guardian.
But wasn't it sounds from listening to the appellant that there's a lot more that Ms. Morrissey was doing than just for Zachary, than just what the trustee was doing to monitor what's going on in the trust. That they're, helping him to arrange to have the taxes paid and doing a lot of coordination with all the different properties, and there's certain properties that aren't in the trust that need some kind of help. So did the court consider all of those different things?
Judge Kennedy was in I think an amazing decision, 22 pages long.
Yeah, I read it.
Exhaustively looked at that and said, for example, first of all, we have to understand this is a bright, young, intelligent man. He signed his own tax return. He does have a 1040. He signed his own lease. He does a lot of things. 3 months after the guardianship, he went off on his own to London for 4 days. Very capable young man. That being said, the solution to reviewing accountings, when the accountings are filed, for example, in the surrogates court, is Zachary can appear, Zachary can retain counsel, Sabrina Morrissey could retain him, he can sign a POA, Judge Kennedy noted that in particular, and a GAL, as long as there's a guardianship of the person, a GAL would be appointed. So he has complete ability to review other accountings or protect his rights in other respects. And, of course, Sabrina Morrissey continues as guardian of the person. And the judge also noted she can be retained as a finance manager, completely separate from being a guardian. But I would like to respond to what...
Whose choice would that be? Would
Zachary.
And Zachary, and then you'd make an application to the court, right?
Should be paid so that property, a property assistant, I forgot the terminology that Judge Kennedy used, but it's common with people that have disabilities, that they have someone assisting them. It doesn't have to be a guardianship. It could be someone that's hired for that purpose. But if I may, could I respond to Justice Pitt's question concerning other assets? The other assets that exist today, as of the time of the hearing in 2020, were very, very modest, some personal effects, and of course, money that were distributed to him. Sabrina Morsi, of course, gave him, I think it was $78,000 a year to administer on his own. Very capable. Any money that he would inherit with regard to, because as a result of Margot's death, his mother's death, he doesn't inherit directly. There's two trusts that indeed now, in the GRAT, he would be the sole beneficiary, but it's still in trust. With regard to the real estate trust, that's true. It divides into Ben versus the brother versus Zachary. But that whole issue as to then what should be done with that and how that will be resolved will be in the accounting in that trust, and it's not part of this record. This record is what took place in 2019, 2020. There could be another application if necessary for guardianship of the property, if somehow changed circumstances would dictate that. But that's not before this court at this point. There certainly is no necessity for that. Judge Kennedy can make findings of fact which are supported by the record, and she certainly did not abuse her discretion as a Supreme Court judge.
Counsel, can I just ask you, you're not in any way debating that Zachary wanted the guardianship to continue, is that right?
There's no debate of that. He did want that.
How does that factor in, or what weight should that be given, or should have been given by the lower court in determining whether the guardianship was still necessary?
Before you get to the issue of consent, or for that matter, incapacity in a different situation, not this situation, you have to talk about necessity. That's the first thing. And if...
It's their burden.
Pardon me?
In that
Absolutely, clear and convincing. The law is clear. They try to get around it with matter of anonymous. Matter of anonymous was actually Judge Kennedy's case before she came to this court. But so she's very familiar with that. But that has nothing to do with a situation where you had a 2-year limited guardianship as opposed to an unlimited situation. That's a very different factor. That's not before this court at all.
Okay, thank you very much. We'll hear from the other side now.
Yes, very quickly, I disagree with my learned friend and colleague. The burden of proof remains on the Londons. Matter of WW, Anonymous 1, Anonymous 3.
Wait.
I'm sorry.
Doesn't the petitioner have the burden here?
No. And again, let me explain why. This was a continuing guardianship case. The index number remains the same. No judicial notice was taken.
A guardianship that expired, am I right? It's a guardianship that expired.
It was a guardianship that was continuing on during the course of the hearing. And it was a guardianship where Zachary London had consented to the guardianship, and where he was a person in need of a guardian.
Yeah, but you already you were the one that told us, and you're right about this, that first we have to deal with necessity before we deal with the issue of consent. So obviously there was a guardianship in place for 2 years. At the end of the 2 years, wasn't it you that made the or was it?
It was Sabrina Morsi who made the application.
Sabrina Morsi made the application to continue on for additional time.
You know, Your Honor.
You didn't have the burden of proving why you should have to do it. He had a burden of proving why.
He had the continuing burden of proof, but notwithstanding that, on the objective record here, the objective record shows that there was actual need for the continuing guardianship. Let me remind the court that 2 years previously, the lower court said that none of the trusts that were in place for Zachary were sufficient available resources that would satisfy his needs for a property management guardian. Fast forward 2 years later, the claim is that an abusive trust that was decanted, to which assets were decanted into, which said if he looked into any trusts that were set up by his family members, that the trustee had the discretion to withhold monies that he needed to live on to defend London family trusts. He wasn't made better in 2 years in terms of his abilities, or his needs weren't satisfied better by this trust. It was made, if nothing else, it was worse.
You said, I think it was you that said that Ms. Morrissey provided Zachary $78,000 a year while she was the property guard.
My learned opponent did.
So I mean, don't the trustees provide him with the money that he needs? If I mean, don't they say, okay, what do you need this month? I know that there's a woman, Miss Crawford, that was mentioned in Judge Kennedy's decision, who I think comes in and helps him in his apartment and helps him with other things. And so Judge Kennedy felt with Miss Crawford around, with Morrissey as a continuing personal guardian, that was sufficient, and with the trustees taking care of the trust, that was sufficient for him at this time.
Ms. Morrissey was the person who gave him the money to use, as discretionary funds. He was, look, you and I don't live the way, the rich, it was Lifestyles of the Rich and Famous years ago. I wish I lived like that, and I'm sure you do too. But the fact is, he's wealthy, he comes from a wealthy family, he knows how to spend money, he knows how to go on Amazon, he knows how to go on eBay.
So do you have the right at any time to go back to whatever judge now has this case? I know these cases are continuing, I used to do them myself. So whatever judge now has this case, can you go back tomorrow, next week, whatever, and make an application to restore the property guardianship based on changed circumstances?
Your Honor, yes. The answer is that a new guardianship proceeding can be commenced if this court fails to reverse the lower court determination. I respectfully submit, however, that the lower court should not have ruled the way it did. There was a failure to appropriately place the burden of proof on the right parties, and objectively, as a matter of facts, on an objective look at the facts in this case, and in the record, that there was a need, that Zachary had a need for a property management guardian, and that he consented to the guardianship. It should have been continued.
Okay, counsels, we will review this. We thank you very much for the argument, and we have one more case. Yep.
Thank you, Your Honors.
We want those people to get here before tomorrow. Okay. Semper versus Karamitsos. Last but not least. You heard a lot of interesting things today, right?
Good afternoon, Your Honors.
Good afternoon.
May it please the court. My name is Olena Sharvan, and I'm here for appellant defendants, Dr. Blatt and Blatt PC. Since plaintiffs, by their responsive brief, they withdrew all liability claims with respect to Dr. Blatt himself, I will focus my argument only on the issues pertaining to Blatt.
So it seems that they relied a lot on a couple documents in the record where both Platt PC and the Eastside Gynecological Services were both on there because they both are in the same location. Admittedly, he owns that. And in a couple of the documents, I think it was a surgical, something there, it actually had both of the things, and they seem to rely on that a lot. What happened there? Why shouldn't they be able to say, well, sometimes you do, sometimes you don't, it's a question of fact?
Yes, so what happened? In this case, this is undisputed that two facilities, they share the same address, the same location. According to the official records, they even have the same phone number because they are on the same floor. But according to the state record, those are two separate entities. Both entities are owned by Dr. Blatt himself. But in this case, there is no proof whatsoever that Blatt PC is the owner of Eastside Gynecology. And it's true that there are documents, actually, there are two pieces of paper in, if I may say that, in medical records from Eastside Gynecology that bear the letterhead Blatt PC. And it was explained in the sworn affidavit by Dr. Blatt himself that this is a clerical error. There is another clerical error in this case that Dr. Blatt was listed as a provider because computer system automatically generates its name. There was no signature by him, nothing. And plaintiffs understood that and they withdrew their claims against Blatt PC. So we believe and we argue that the mere thing that there are two pieces of paper in the record bearing Blatt PC's name cannot be sufficient to find the issue of fact as to ownership of Eastside Gynecology, especially when we have an official record stating who is the owner.
Tell me if I missed something. Was there anything in the record that said that they had the same reception desk or the same staff or the same doctors? Is it only the same address and the same office space?
So this goes together with the same office space. They had same office space. There is nothing in the record with respect to a receptionist. There is no testimony to that. There is no documentation showing that. The only evidence in the record is that they had the same office, the same address, the same phone number, the same owner. But they were operating as different entities. And as Dr. Maslin, who performed the procedure, testified himself, Eastside Gynecology was only for abortions, and another side, Manhattan GYN Services, was for regular GYN visits. So their operations were different. Their management is different. Those are two
Are they
different
both
corporations.
separate corporate,
Those are two separate legal entities. They are professional corporations. And simply, we made this argument to the lower court, and we made it again. Plaintiffs, they brushed over that argument that even if there is a question as to ownership by Blatt PC of Eastside Gynecology, still no case was made to pierce the corporate veil. And the ownership, honestly, shouldn't make any difference in this case, as we have Eastside Gynecology, who is a facility, who is corporate entity. The procedure was attempted there. Plaintiff presented to have the procedure at Eastside Gynecology, and there is nothing in her testimony in the record, paper documents, that show that the procedure was done at Blatt PC, and Blatt PC was in any way involved in plaintiff's care in this case. And, but there's another reason why this case should be dismissed by the lower court, is lack of expert opinion in this case. Plaintiffs,
what did you just say?
Oh, so there is no sufficient and admissible expert opinion in this case, because we made a prima facie case showing that we are entitled to summary judgment motion, and plaintiff was supposed to submit an expert opinion showing that there is a departure, proximate cause between departure and damages in this case. And here, the opinion was submitted, but it offered new theory of liability never raised, and it didn't offer opinion as to proximate cause, because
okay, you have 2 minutes on rebuttal, so let me hear from the other side, please. Thank you.
Good afternoon, may it please the court. I'm Annette Hassapidis, appearing for the plaintiffs in this case. Turning to the principal issue that was addressed here, which is the liability of Blatt PC. The case is significant for what Dr. Blatt didn't say. There is, the evidence here is that Dr. Blatt was the sole owner of 3 entities, one of which is Blatt MDPC. And Judge Kapnick, as you pointed out, 2 pages of the medical record, it was the post-surgical nurse's note, used the letterhead of Blatt PC. No evidence or explanation was ever proffered to explain why that letterhead was used in the medical records. Now, counsel has referred to Dr. Blatt's affidavit, but frankly, Dr. Blatt's affidavit doesn't answer the question. So here's an opportunity for him to explain why Blatt MDPC letterhead is used in the medical records, and all he says is
I
that—
thought the explanation was that it's a clerical error. Is that enough?
Well, no, he says his name appearing on the chart is due to a clerical error. He says nothing about his corporate entity. That's the issue here. Paragraph 6, page 212 of the record. The electronic system automatically listed Ronald M.D. as a provider. Again, no reference to the corporate entity. According to Eastside Gynecology's chart, the procedure was performed by Maslin. So he never presents any evidence on the motion or in the reply to refute the argument that the presence of Blatt MD-PC in the medical records raises a question of fact whether that entity is vicariously liable for Dr. Maslin's conduct and the actions of the staff during the procedure. In the reply,
But aren't they two separate entities?
Well, yes, they are two
legal
separate entities, but the issue here is who is vicariously liable for the staffing and for Dr. Maslin during this procedure. The issue is not answered on the papers. There's no evidence presented. Counsel's reply brief addresses it at page 4, but it's a hearsay statement that's unsupported by the record saying that staff used the wrong form. There's no evidence to that effect. Dr. Blatt never said it. Dr. Blatt only referred to the incorrect clerical error with respect to his name as a provider, and that's not an issue here. He never took the opportunity, either on the motion or in the reply, to refute that contention.
Counsel, but doesn't Dr. Maslin, didn't he say that he was employed or received checks from ESG or Manhattan Center for Gynecology, never mentioning Black PC?
Now, that's correct, Your Honor, but the significance of Dr. Maslin's testimony in that regard is to show that these entities were interchangeably used. Dr. Maslin testified that he didn't recall which entity paid him. Now, he's a doctor. He knows who he's working for, but his testimony was that it was either one or the other entity that paid him. Admittedly, he did not reference Blatt MD-PC, but the point here is that Dr. Blatt owned all three entities, and there's a question of fact that has not been answered, I mean, in this record and even on the appeal, as to why the post-operative nurse's note included that. There could have been, the reason could have been that the staff is employed by Blatt MD-PC. We don't know that. I mean, it is a nurse's post-operative note. So clearly, in the absence of evidence from them as to why it appeared that way in the records, it's a question of fact that should go to a jury. My time is running low, so I'd like to address the issue of the expert opinion testimony. I'll say preliminarily, looking at this case, I don't think a jury needs an expert to appreciate that taking a pill carries no risk of an infection like MRSA versus a surgical procedure. And that was the causation opinion here. The causation opinion was that she was, I see my time has lapsed, but
No,
may
go
I
ahead, go ahead, finish.
Thank you.
Raise that below?
I'm sorry? Yes, I mean, the expert's affirmations and counsel's affirmation stated that this woman was not a candidate for a surgical procedure. She was morbidly obese, she was epileptic, she was 41, and she had fibroids.
Did you include that in the pleadings?
I'm sorry?
Did you include this in the pleadings?
In the bill of particulars, and I know that was an issue raised, I would refer the court, where I block quoted at pages 30 to 31 of my brief, the language that they failed to adequately advise plaintiff of the risks, problems, and alternatives to the subject procedures, therapies, and treatment, and that they failed to time, and at page 31, in failing to timely undertake necessary and indicated medical management, pharmaceutical treatment, and surgical treatment. And we would submit that, having to take a liberal view of the pleadings, that this encompassed a medical abortion. I mean, the testimony in this case revolved around the different options available to her. Plaintiff was asked at her deposition whether the issue of taking an abortion pill was raised by Dr. Phillips and Dr. Maslin, and she said she had no recollection of such a conversation with Dr. Maslin, but she did with Dr. Phillips. I do not want to exceed my time, unless, thank you.
Thank you, Ms. Hasapides.
Your Honor, two issues. One is with respect to vicarious liability of Blatt PC. As Your Honor pointed out, Dr. Maslin himself testified that he was employed by Eastside Gynecology. His testimony as to where from his check came in, he was employed there for a lengthy period of time. That sentence was taken out of context because when Dr. Maslin testified directly as to care and treatment provided to Ms. Semper, he was clear that at that time he was employed by Eastside Gynecology and the services were provided by himself at Eastside Gynecology. There's no other issue with respect to his employment, and since he was not employed at that time and he didn't work for Blood PC when he provided services to the plaintiff, Blood PC there is no reason to hold Blood PC vicariously liable for his actions. Also now, plaintiff's counsel mentioned that maybe nurses were employed by Blood PC. Unfortunately, for them, in their pleadings, in bill particulars, there is no claim of any negligence as to staff at Blood PC, even as to staff at Eastside Gynecology. So that would be a new claim that cannot be allowed during the appeal. As to medical abortion, again, as I raised before, this is a new theory. It wasn't raised in the pleadings. This quotation just made by plaintiff's counsel is very broad. It's not enough to put the defendants on notice of their claim. This was very general, encompassing anything, whatever could be claimed. And with respect to proximate cause, plaintiff's counsel now allude to common sense argument that it raises the risk of infection, unlike surgical procedure. But there is also another aspect of this case. The surgery wasn't actually performed in this case. It was attempted, it was started, but no tissue was broken in this case. The procedure was attempted, and before the fetus could even be reached, it was aborted. So there was no damage to tissue, there was minor bleeding, and if this argument is maintained, anything that happened after the surgery, attempted procedure in this case actually could have the same result and the same risk of the infection. Thank you, Honors.
Okay, thank you, everybody, and have a nice afternoon.